Good evening, everyone, and welcome to the Oxford Board of Selectmen's meeting. We have a rather long agenda tonight. Before we get started, I'd like to read the following statement. In accordance with Mass General Law, Chapter 30A, Section 20, I am advising all those in attendance this evening that this meeting is being recorded by the Town of Oxford. In addition to the Town of Oxford, Robert King of Quabog Ave is recording the meeting at this time. All right, thank you. So we're going to start off with going with an executive session pursuant GLC 30A, Section 21A, to discuss complaints or charges brought against a public officer, Board of Selectmen, open meeting law complaint by Robert King, November 23rd, 2022. Acknowledge receipt and review of the complaint. Authority submission of response by the town council. So we're going to be going into executive session to discuss this complaint. Robert, I do have a question for you. Because you are the complaint, do you plan on taking part in this hearing?
So it wasn't really clear to me what the purpose was, because it was a purpose 7, and then a few minutes ago we changed it to a purpose 1. So I was willing to provide facts to the board as to kind of my knowledge as a board member. But I wouldn't want to be voting on it. It would be an appearances issue, and I just don't think that it would be appropriate. So I wasn't intending to vote on the decision. But in light of this being changed to a purpose 1 executive session, I mean, to be honest, it's very amusing, and I don't want to take part.
So you're not going to take part in this
No.
session? Thank you very much. So with that,
You'll need a motion and then
I am going to look for a motion to go into executive session.
I will make a motion to go into executive session under MGL Chapter 30A, Section 21A1.
I'll second that.
I have a motion and a second. Any conversation? Call for vote.
No, Mr. Chairman, before you take the vote, just since we're going under exemption 1, under exemption 1, since the complaint is against the select board members, each member was entitled to notice of this matter, which they would have received through the posting on the agenda. But I would just ask that each of the select board members indicate that they would waive the 48 hours notice that they were otherwise entitled to under the statute.
Okay, so
Need to hear from each one.
before you
I
vote, would you
waive the
waive?
48 hours.
So don't I waive the 48 hours.
I do not waive the 48 hours.
Tim?
I'd like to understand better what's the 48 hours?
Is it under the open meeting law? There's simply a process when we go under exemption 1 to hear charges and complaints to allow for a 48 hours notice prior to. You had noticed because the matter was on the agenda, so this just essentially waives you having been formally served with the notice.
No.
Okay, and I vote yes. I will go along with waiving the 48-hour notice. Now we can call for the vote?
But we have a member who did not waive the notice.
So what's that mean?
So, we without the waiver of the notice, we would have to proceed at a later time to provide that notice. Otherwise, we could proceed in open session. That's the decision of the board, if the individual won't waive the notice.
The three of us couldn't do it? No.
You have a member, unless that member chooses not to participate, but he's entitled to notice, he's entitled to the 48 hours notice, and he's choosing not to waive that notice, which would prevent you from going into the executive session.
So we could reschedule it?
You could reschedule it. We have to reschedule it soon because we have to make our response to the Attorney General, or we could seek an extension if we don't have enough time. I don't know when this would be continued until.
Would we could do the whole thing in public and let everybody know what's going on? I don't.
Even though it's listed as an executive session, you could proceed in open session if you so choose.
So we got the complaint on December 4th. How is that not 48 hours notice?
Because the specific notice as to proceeding under exemption 1.
Oh. Okay, sorry.
What do you recommend? Because, I mean, we do have, some names involved and stuff, and
Well, we would have to be very careful in the discussion in open session. But again, we received it, I think based upon the receipt of this complaint, I think that we do have some time it was received on November 23rd, and, just gonna check the calendar again, but we have 14 business days within which to submit the response. So based upon having received it on the 23rd, it's due.
We do not have business days on the 24th and the 25th.
It will be due on December 13th.
What's the
Actually,
pleasure
no,
of the
December
board?
14th, because there was the holiday.
I have no problem with
Between-
discussing this in open session. Personally, that's,
If you want to proceed in open session, we certainly can proceed in open session.
You'll kind of give us the guidelines if we get out of hand, or?
Well, I know well, one of the documents included in the open meeting law complaint was a communication from counsel that's a privileged communication, so I'd recommend not obviously discussing directly that communication. Again, it's, if the board has the opportunity to have a meeting between now and the 13th, so we have, today's the 6th, we've got a little bit of time. You would need 48 hours notice to have the meeting, and then we would send the notices to each of the members, and then we could proceed in executive session at that time, whatever the preferences of the board.
So, Mr. Chairman, I would have concerns as an employee, as well as a number of employees, based on this specific type of open meeting law complaint that actually involves and invokes specific names of employees in it, that I would be very concerned for their personal safety and welfare, and I do not think that it is something that I would want to have in open session.
I agree.
All right,
Sorry,
so let's
guys.
pick a date when we want to have it. Board, what's the date you'd like to have it?
whenever, May.
Next Tuesday? Would Tuesday work?
Tuesday's the 13th, isn't it?
Oh, yeah, it is. So what's the first day we can have it? Friday?
No, you could have it Thursday, well, yeah, you could have it Thursday if you post it, if we were to have, no, because the clerk's not here, so it won't be, it would be Friday.
All right, how about Friday at 6 o'clock?
Fine with me.
I'm good.
Fine with me. So I would need a motion, right, to reschedule this executive session for this Friday at,
Mr. Chairman, I can't be at that meeting.
okay?
Can we do Friday at 4? Would 4 work for you, Dee?
Yes.
All right, so
We
let's,
also have Monday the 12th.
Monday, the 12th.
all right, let's do Monday the
do that.
12th at 6 o'clock. Okay, so I'm going to look for a motion to reschedule this executive session for Monday at 6 o'clock. And what's the date, Monday?
The 12th.
12th, at 6 o'clock.
I will make a motion to reschedule the executive session from Monday, December 12th at 6 PM.
Okay.
And I will second that motion.
Okay, any discussion? I'll call for the vote.
Yes.
Yes.
Abstain.
Yes.
I'll vote yes. Let the record show 4 in the affirmative, 1 abstention. Executive session will be scheduled for Monday at 6 o'clock, all right? Thank you.
Okay.
We just continue?
Yep,
Take a
you,
recess?
you would,
Huh?
what was that?
You're taking a recess?
Yeah, no, because you had the meeting start at 5:30, so you would be going into you're already into regular
Well, yeah, but
session.
at 7, do we have to stick to 7 o'clock?
So you can come back to 7 o'clock, but you could proceed with the rest of the agenda unless there is an actual public hearing put on that. So
All
it's up
right,
to you,
so why
Mark,
don't we,
to-
Well, there's no, the meeting was called at 5:30. The only issue would be the tax classification hearing starting at 7 o'clock, the public hearing at 7:15. So those two matters would have to be
Yes.
no earlier, but you could proceed with matters C, D, and then jumping right to G if there's time. And then take that ahead of your time-limited matters.
the board okay with that? We'll
Yes.
just continue? Haven't been
Yes.
here that
Yes,
long.
please.
Okay.
Let's please.
All right, so let's start off with the Pledge of Allegiance.
Allegiance.
Sooner the better.
I pledge allegiance to the flag
Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible,
Thank you. All right, so we're going to go down to D, and it's going to be a moment of silence. We'd like a moment of silence in remembrance of Donald Johnson, who was a former town employee. Donald A. Johnson passed away on November 19th. Donald served the town of Oxford as a volunteer firefighter for 12 years, and from 1975 to 1987. The Board of Selectmen and the town manager extend their deepest sympathies to Donald's family, and friends are grateful for this service to the town. We'll take a moment of silence in remembrance of Donald. Thank you very much, and thank you to Donald for his service. All right, E and F we're going to skip because they are time sensitive. All right, G. I've asked town council to come here tonight and give us some information regarding that, but we are going to review the Attorney General's determination on the annual town meeting articles. Town Council Mark Rich of KP Law will be present to apprise the board of the ruling of the Attorney General's office. We're going to let Mark make his presentation, and then we can ask him questions, and then go on from there. But Mark, the floor is yours.
Thank you, Mr. Chairman, through you. As you're aware, by statute, amendments to articles, amendments to bylaws, be they zoning articles or general bylaws, are subject to review by the Attorney General once passed by town meeting. So in accordance with that process, the Attorney General issued on November 28th the decision with respect to the May 4th, 2022 town meeting and warrant articles 14, 15, 16, 17, which were zoning articles, and articles 18, 19, and 21, which are general articles. For this discussion, I think probably the primary interest is Article 21, which was the petitioned article. The other articles, the zoning articles, are somewhat complex articles having to do with the battery energy storage systems and issues that were raised with respect to Chapter 40A, which does protect solar energy and other energy projects. Chapter 40A is the Zoning Act. And so it lays out, especially in Chapter 48, Section 3, limitations on zoning and what is protected under zoning. So what the Attorney General has done, the Attorney General did approve the battery energy storage articles, the various articles that were provided. There was no disapproval of those articles. But what the Attorney General did was give extensive comments and just cautions, because even though the town enacts bylaws, those bylaws must be applied consistent with state statute. And so a bylaw, as opposed to a charter or a special act, a bylaw is subject to the provisions of a statute. And so in this case, your zoning is subject to what's allowable under Chapter 40A. So there are numerous cautions within this opinion that are consistent with cautions we've seen in other towns, reference to the Tracer Lane cases, which discuss limitations on what a town can do in enacting regulations that might impact solar projects. One of the key features in Chapter 48, Section 3, is kind of a promotion of certain essentially alternative energy projects and to encourage the development of those projects. And in this case, just a caution to make sure that when you apply the bylaw, it's not applied in such a way as to prohibit or improperly limit those projects. So I know there will be discussions between my office and Tony Souza as this goes forward to make sure that these issues are fully understood and fully vetted, because they are complicated. They're not really the kind of things that the Board of Selectmen deals with on a day-to-day basis. These are more things that will be dealt with by the Planning Board when projects are brought forward for special permits, or the Zoning Board of Appeals if there are requests for zoning relief. So I don't know that we want to spend a lot of time on those because it's really, the zoning is not, as much as the select board is the chief executive body of the town, and we'll get into that in a moment in terms of policy setting, but you don't really set land use policy other than overseeing the warrant and putting articles before town meeting. The actual implications and determinations of matters of zoning and land use come before your land use boards. Then there was Article 19, which had to do with the application of Chapter 40U, which has to do with an administrative process for collection of fines. And there was simply the warning that, again, that this must be undertaken in accordance with the statute, which limits when that process may be undertaken. It did recognize the higher fine limit that was placed by the town for these violations. As you know, most fines are limited by law to $300. But under Chapter 40U and under the State Sanitary Code, you could actually implement a higher fine. And so that was approved by the Attorney General. The Attorney General just cautioned that where there's a reference to other bylaws of the town, they have to be the bylaws that are subject to enforcement through this process by statute. So again, the statute dictates where you can go with this. So it's again an as-applied situation to make sure that you stay within your guardrails that are set by the statute. But otherwise, the bylaw was approved. There was no disapproval. Nothing was stricken from the bylaw. So unless you have any questions on that one, again, it's a process that's limited by the statute as to when you could apply that process, and the bylaw as proposed is consistent with that statute. Article 21, of course, was the citizen petition article that had to do with changes to the town's bylaws with respect to public meetings. And it's an interesting discussion because I've had the opportunity to discuss similar bylaws and similar determinations with the Attorney General, because these issues have come up in a number of towns, and in a number of cases, the Attorney General has specifically stricken bylaws that are deemed not to be consistent with the open meeting law. The open meeting law, as you know, very strictly regulates not only how meetings are conducted, but the authority of the board, and particularly the chair, as to the conduct of those meetings and what is and is not allowed. So again, we're back to talking about guardrails and what is allowed by statute, and that statute sets specific guardrails and provides for specific authority. So in this case, as you're aware, the proposed bylaw amendments had particular sections that the Attorney General reviewed individually. Section 1 was essentially just an opening section. Section 2 had to do with proposed additions or limitations on what would be placed upon an agenda, and specifically required that all Board of Selectmen meetings shall have on the agenda an opportunity for each selectman to ask questions, comment, and call for items for the agenda of the next selectman meeting, any agenda item requested by any selectman in good faith, an opportunity for public comments. That particular section came under significant scrutiny by the Attorney General. There was also further discussion about Section 3 that had to do with the posting of agenda, expanding the obligation to post at least 5 business days in advance, and requirements with respect to public comment and remote viewing and remote participation. And Section 4 requires that all meetings be video recorded and the recording made publicly available within 2 business days following the open meeting. So the Attorney General spent quite a bit of time, again, reviewing Section 2, which dealt with the agenda specifically of the Board of Selectmen. And in this particular instance, the Attorney General did strike that and did not approve Section 2. So the Attorney General's determination that was that Section 2 is in violation or inconsistent with the provisions of the open meeting law. And the Attorney General did cite to a number of cases in making this determination and reviewing the executive authority of the Select Board, the Board of Selectmen, and specifically what the Attorney General was citing to, which is what has been cited to in other decisions similar to, with respect to similar bylaws proposed in other towns, is the language under Chapter 30. Chapter 30A is the open meeting law, or contains the open meeting law. Chapter 30A, Section 20G, and the language that says, "No person shall address a meeting of a public body without permission of the chair, and all persons shall, at the request of the chair, be silent." So what Section 2 would have done would have required that the chair essentially abdicate that authority and allow for public comment and public discussion, when in fact the open meeting law specifically gives the chair the authority to determine who gets to speak at a public meeting. And keep in mind, the intent of the open meeting law has always been to remove the secrecy from the functioning of town government. So it was intended to allow meetings or require meetings to be held in public rather than meetings to be held in back rooms where nobody knew what the business of the town would be. And it was developed to allow the public to observe the actions of the public bodies being elected or appointed boards and committees and commissions of the town, and as specifically defined in the open meeting law. It did not contemplate a situation where essentially meetings of public bodies would become town meetings. Town meeting is the opportunity where, town meeting is the legislative branch of the town. And that's when the town, through all of its residents in the town of Oxford, it's an open town meeting, meaning that any resident of the town who is registered to do so may attend the town meeting and vote on legislative matters such as bylaws and amendments to bylaws and appropriation of funds, determination of certain actions as required by law, the acquisition of or disposition of real property. There are specific actions that must be brought before town meeting, certain statutory acceptances, and state statutes specifically delegate when that authority runs to town meeting. But in this case, the operation of public bodies at their meetings is governed by the open meeting law. Interestingly, town meeting is not subject to the open meeting law because town meeting has essentially its own set of statutory guidelines under Chapter 39, and it allows for a much more open process. You don't have many of the same guardrails, so to speak. So again, what the Attorney General has determined is that by imposing these requirements under Section 10, essentially what the bylaw would have done would have been to remove from the board, from the chair, the authority that's given by statute. And again, bylaws must be consistent with statute. They're not the same as, they don't have the same status in terms of enforceability as a statute. And in this case, Section 2, which would have required that certain items be placed on the agenda. Again, the agenda is set by the chair because the chair determines who gets to speak, and therefore, under the regulations and determinations of the Attorney General, it's been determined that the chair has authority over that agenda, because the agenda is what the board speaks upon. So that sets out what you can speak to, and therefore to require items to be placed on the agenda, and this is discussed throughout this opinion, would essentially remove the executive authority that's included within the authority of the board. And then requiring an opportunity for public comment, again, is inconsistent with that provision that I read to you from the open meeting law that says no person shall address a meeting of a public body without permission of the chair, and all persons at the request of the chair shall be silent. So the Attorney General specifically struck that provision. I don't know, Mr. Chair, if you want to have questions as I proceed, or if you want me to just continue.
I think you've got two things right now. Would the board like to ask questions now, or let the attorney, Rich, complete his presentation, or do you want to ask questions now? Let's the pleasure of the board. Amy?
I'm good, but it looks like Mr. King wants to ask a
I'd
question.
like to point out that the Attorney General didn't strike Section 3, which says the same thing about all the other boards. And when you look at the decision at length, they talk about at length the executive power of the Board of Selectmen, but they don't say that about the other boards. And so they just say you have to apply it consistent with the open meeting law, in the same way that if somebody comes up to speak for a public comment, the chair can tell them to stop speaking or tell them to, or to wait for the next person or whatever. It's just, I don't really see an issue here. And I believe our open meeting law training in the spring actually said, Attorney Goldberg said that some towns actually have this as part of their charter. So I don't know how that would work if that's not in compliance with the open meeting law.
If I may, I haven't
Yeah.
even gotten to Section 3 yet, so I
Yeah.
appreciate the comment, but I hadn't even spoken.
we haven't
were-
gone there yet.
We were discussing Section 2. As to the comment about a charter, as I said earlier, I think you may have heard what I said earlier, where there is the primacy of statute over bylaw. A charter is essentially like a special act. A special act allows for changes. So, for the edification, a charter has a different status than a bylaw. Then what we're discussing is a bylaw, not the charter.
Yeah, I just want to clarify, it's not against the law to have public comment in meetings.
I don't
Well,
think
that's your opinion.
I don't think anybody said that.
Yeah, no one said that.
Mr. King
Yeah,
might
be
find
very
this
careful,
humorous, but
Robert, you don't
that's not
start
what was
misleading the
said.
public, because that's not what was said. Okay, I mean, I want you to be able to speak, get your point out, but be honest with people. That's not what he said, okay? So please, give us your comments, but don't try to mislead the public,
I understand,
okay?
Mr. Chairman.
And that's why we have him here tonight, because he's our legal counsel. They're on the town side, and they're going to give us the advice that's best for our citizens, not for certain individuals in town, okay?
I understand, Mr. Chairman.
Thank you, Mark. Sorry for any other questions, by the way? Tim? Dennis?
No, I'm good with 2.
Okay.
And I will add, I am aware that a number of towns and a number of boards do have public comment periods.
Absolutely.
And, that's a policy determination. However, there's ongoing litigation in this current litigation that's before the Supreme Judicial Court, and there's been previous litigation in different courts as to the extent of limits on public comment. And the concern that has arisen is towns have attempted, through their public comment procedures, to put guardrails to try to make an orderly process when public comment has been allowed. And at times, there have been certain limitations that have led to litigation. So you have situations as interesting as what's being currently discussed is a requirement that speakers be courteous, or that speakers refrain from personal attacks or other disruptive behavior. And in imposing those restrictions, once a public comment period has been allowed, the issue now is whether that has created essentially a public forum in which individuals can speak on essentially any matter without limitation. You get into whether their First Amendment rights, issues of time, place, and manner restriction as allowed under the First Amendment. So there's a lot of litigation ongoing as to whether once there is a public comment period placed on agenda, what limitations can be placed on that. And recognizing that the open meeting law has that language that allows the chair to indicate that an individual must be silent and to not allow individuals to speak, there is the question about once you've opened that forum, whether you've essentially abdicated that ability and then run the risk that the meeting can become a free-for-all because of the lack of limitation. The concern that civil rights issues arise when members of the public are able to speak before a board and speak about others, speak about employees, speak about and this has happened where one individual got up to speak favorably about a town employee, another individual then got up to speak negatively about that employee, concern about that employee's rights. The chair stopped that discussion, and a lawsuit ensued, and a Superior Court case didn't go beyond Superior Court, but Superior Court found that if you're going to allow a positive, you have to allow a negative. And so the concern that at that point, you've kind of opened up almost an opportunity for individuals to come in and bring complaints and raise issues that are not before the board, that are not on the agenda, that may not even be within the purview of the board, and that may result in discussions that could impact the individual's civil rights or public safety issues, discussions of items that may not be appropriate for the particular board they're brought before. And so those concerns have led to a number of municipalities determining that public comment is not necessarily in the board's best interest because of the potential that you will not be able to control what is discussed. And I know that there's always this concern about control and individuals who hear that thinking, why should there be control? But again, we get back to the basic purpose of the open meeting law, which was to the concept of transparency, to allow the public to observe the process of government, but the public, the select boards and even the quasi-judicial boards, such as the zoning board and the planning board, they also serve executive functions. And when they're carrying out that executive function, that's the function that's been imbued within the board itself, the authority by statute and by charter. And so the board carries out those duties and authority. Generally, if the public disagrees with how that authority is carried out, there's the opportunity for the public to vote in a new board. But it's not intended for the public to be undertaking the very role that has been given to the various boards. The boards carry out their role, and the public observes that process being undertaken. So there are concerns that have been expressed in numerous communities about the outcome of public comment when boards need to actually attend to their duties and instead are concerned about possible discussion about matters of litigation, matters of civil rights, matters of personnel in a public forum when, again, there's the opportunity for executive session. There are certain things that, as an example, a town manager, a city manager, town administrator addresses on a day-to-day basis that are generally not matters brought before the public because they could impact public health and safety, and they could impact the rights of personnel. So there are a number of issues to be considered when reviewing the concept of public comment.
Any comments or questions regarding that about public comment? And
Yeah, I understand the sorry, through you, Mr. Chair.
No, that's fine.
I understand the concern with litigation and things like that, and I guess you've really addressed it, that it's, the chair can do it, but, in your opinion, it's, and several other opinions, that it's not a good idea. But, I mean, in this process, I myself have reviewed several towns and also spoken to residents of that who advocated for it, and it seemed to work well, and I'm not saying that's the same thing for every community. I understand. I guess what I'm saying is I understand. I understand the view and the process. It's just, I guess it's just a little bit disappointing that those things haven't been brought up in discussion other than this.
Well, I think to that point, it works well until it doesn't, and that's always the concern. I know there are members of the public who really look forward to those opportunities, but the problems arise, and they may be few and far between. But when they arise, they can create certain and significant issues, and that's why, again, as with so many circumstances in day-to-day life, things work until they don't, and it is a difficult process. Once you open that door, the door gets opened very wide, and you lose that ability to regulate a process. You have a very regulated process in terms of your agenda and consideration and procedure. And once you get past that, those guardrails go away. And so, it works until it doesn't.
I guess I just have kind of a follow-up kind of with that. So it is the discretion of the chair. So at the point, if the chair wanted to, and let me know if I'm going off topic here, If the chair wanted to institute it, could he alone also institute parameters, or is it only the agenda? Would the board have to vote if he wanted to put that on the agenda? Would the board have to approve the parameters in which it's conducted, or could the chair do that at his sole discretion?
Well, again, that gets back to that very stringent language of the open meeting law. So the chair does, it's interesting, when I speak to boards, I'm always reminding boards that each individual is an individual member of the board and can't act except through the board. The chair is imbued with very specific authority. It's very limited. There aren't very many times when the chair really has any more authority. The chair's vote is the same as anybody else's. But in this case, because of the interest in protecting the process and avoiding what may be a total disruption of process, the chair is allowed to determine whether and when someone can speak. So essentially, the chair can open up the process, but when you talk about parameters, that's where we get into the problems that are currently before the courts. Because parameters, you're now, if you've created a public forum, and public forum, the town square or the soapbox, which is a literal thing. Stand up on the soapbox and make your speech. It's very difficult to limit free speech except with appropriate time, place, and manner. And for the chair to then implement those guidelines, you get into the risk that the chair themselves can violate the First Amendment by saying, as in my example, you could say good things about employees, you can't say bad things about employees. Right. Is that reasonable time, place, and manner? The time and the place is right now. The manner is how I'm expressing myself. Is that a reasonable determination to say we only want to hear good things? That gets into the very concept of you have to be courteous and whether you can require someone to be courteous. So that's why it's almost like an on and off switch. The statute provides that on and off switch. What you're talking about is like a dimmer switch, and the courts don't like the dimmers because that's not black and white, that's gray.
Right. Okay.
I hope that makes sense.
Yeah, I guess just one more if you don't mind. So, I guess I'm just trying to find the right word. So would that be like a policy decision at that point?
Well, policy is made by the board, and the board can implement certain policies, but again, the open meeting law, I know I keep coming back to that, that's that switch. Yeah. And ultimately it gives that authority to the chair, and the fact that you can't do it by bylaw, a lot of towns have a policy that says, we're going to do this, this, and this, and I've been at plenty of meetings where someone has said, to the chair, you just violated our policy because you went right past that, and the chair says, okay. Because the policy is subservient to bylaw, and the bylaw is subservient to statute.
I understand. Thank you for that.
Sure.
It seems like the problem is we can't set guidelines because the previous chairman started looking into having this type of thing, and we got all kinds of guidelines from other towns. But from what you're saying, those guidelines really don't mean a heck of a lot.
Well, what I'm saying is those guidelines are currently under challenge.
Right.
And so it'll be interesting to see how the current cases pan out. Like I said, that one case, it was a Natick School Committee case where you had two parents who got up to speak negatively about teachers because they felt that they had done something that was not right. And it was right after someone had complimented the schools and the teachers, and the chair said, no, I'm not going to allow that because we don't allow personal attacks. And they took that matter to court saying, we should be allowed to speak. You consider it a personal attack, I consider it free speech. In that case, the Superior Court came down in favor of the parents, which, I would have liked to, personally, I would have liked to have seen that go forward to appeal because that implicates the light switch in the open meeting law, and whether a court would ultimately say, you can't silence someone once you've opened that forum. And that's what we deal with so much in civil rights and constitutional analysis, and looking at things as right now we're caught up very much in in flag policies, when, what flags you can you can display, and accessibility for flying flags, and again, reasonable time, place, and manner restriction, and governmental speech. All these things get into the concept of when you open a door to a public forum, it's very hard to close that door back up. You create a public forum, and then you try to restrict that forum, then you're looking at the time, place, and manner restrictions, because one group gets to speak, another group doesn't get to speak. Is that a legitimate time, place, and manner restriction? So when we talk about these guidelines, we all used to feel very comfortable. Be courteous, no personal attacks, address the chair, and again, that works until it doesn't, until someone says, well, I'm being courteous, but I'm saying negative things about someone as courteously as I can. And the chair says, well, that's a personal attack, I'm not going to allow it, hence a court challenge.
I mean, I felt good about that when I read these. I said, okay, we can put some policy together with some guidelines, but it sounds like no matter what we do, we're going to get challenged at some point.
Well, we're
And the
waiting
town's
for
gonna-
we're waiting for the court to make the final determination, but when I speak to boards, I regularly caution on this issue of public comment, not because I'm against public comment, but I'm concerned about the opportunity for board meetings to essentially go off the rails, because you're here, the whole purpose of having an agenda as required by the open meeting law is to lay out what the board is going to consider, what actions, what items are to be considered. And when other items come up, there's the guidance from the Attorney General. Obviously, the open meeting law specifically says that if it's a matter that was not anticipated by the chair within 48 hours, it can be brought forward. But what can be reasonably anticipated by the chair, and then the Attorney General encourages, if it's a matter of real significance, it should be put on an agenda for a later meeting rather than being discussed by the board without having been on the agenda. The whole idea is the agenda, that sets guardrails itself, because the agenda lays out what is going to be discussed. And then if you have public comment that leads to debate, and I've been to plenty of towns where public comment actually results in board members discussing matters with members of the public, you wind up with having discussions on matters that nobody in the public knew, nobody outside the room
not on the
would know.
agenda.
It's not on the agenda. And so you kind of lose that control, and you lose almost the predictability. So when we're talking about transparency, and we're talking about the ability of the public to observe the functioning of government, I didn't know that was going to be discussed. I didn't know that was going to even come up. And now I find out that if I had known that, I would have come to the meeting, but it wasn't on the agenda. And yet it was an hour of discussion on something that a member of the public brought up unexpectedly. So it's really not what was anticipated under the open meeting law, and hence that requirement for a written agenda easily understood by the public, so that each member of the public will be able to understand what is coming before the board and be able to come to the meeting and observe that discussion, not necessarily participate in that discussion, but observe it. And again, if they're not happy with the direction of the board, change the board.
I would like to point out some things, too, that people can get in touch with us. If they want to speak about an issue, we're all, our information is, at the town. Amy and I have office hours once a month. And to be honest with you, the first few months, there were people coming in, good discussion. The last month or two, not too many people have shown up. And I also find that people are much more comfortable speaking with somebody one-to-one. So there is access for our citizens to talk to us about, certain issues that they have, and an environment where people can speak freely, where you can answer their questions, because, as you say, an open comment is really, they just say what they want to say, and that's it. So I just want to let the public know that. But are there any, thank you, Tim, for your questions. Are there any other questions or comments for town council?
Yeah, I'd just like to point out that, so we already have an existing public forum in the town called town meeting, where the town moderator directs people not to engage in personal attacks and stay on topic. And we've managed to go this long without that becoming an issue, and in some cases, people have been removed. And so it's kind of strange to me, this assertion that, well, if we have a public space for discussion, that there can't be any discussion of what the topic is. And this bylaw was written very open-ended. It doesn't say, it doesn't even really define public comment, you know,
Maybe
so.
you should have.
No, actually, I can tell you as somebody who was involved in it, that was intentional. It was written to give the chair as much flexibility as possible, with the recognition that the chair has to be able to control the meeting, but that, you know, to basically encourage the chair to, where possible, allow public comment. You know, it's open-ended on purpose, you know, because,
Maybe that's a bad thing.
well, it's,
Mark, can you respond to that?
Well, I don't want to interrupt if.
All right, yeah, I'm sorry, Robert. Finish your,
yeah, no, I was just saying that, you know, so these things there, I mean, it's not, I don't see how, and the Attorney General doesn't even state, as far as I saw, any way in which it confers new rights over and above what the open meeting law already says.
So if I may,
yeah,
a
go
couple
ahead.
things. Backing into that, the Attorney General simply, struck it and found that it's simply inconsistent with the open meeting law. But to say that it gives more flexibility to the chair, I respectfully disagree. The language of it requires an opportunity for public comment. It doesn't say may, it says shall. And while we could argue about when shall means shall and shall actually means may, in this case, it does say shall. So to state that this was intended to be open-ended to allow more flexibility, that might have been the thinking of the drafters, but that's not what the language says. So it says, shall have on the agenda an opportunity for public comment. If the intent was to recognize the flexibility of or the authority of the chair, that's already embodied in the open meeting law and the language that the Attorney General cited. So that the Attorney General would recognize that there is authority with the chair in terms of regulating speech. The Attorney General has recognized that the chair has certain discretion in that regard. But this is certainly not open-ended language. It's trying to mandate a public comment that's inconsistent with the provisions of the open meeting law.
Could I offer a clarification, Mr. Chairman?
sure.
So it doesn't say how long the comments have to be. It doesn't say any sort of viewpoints. It doesn't even actually say that the public comment period can't be required to be on the topics already on the agenda. It doesn't say any of that on purpose, because the intent was, that the chair would try and, for each board, decide how they could make it work for their board in a way that they were comfortable with.
It's just answered that question already.
Well, again, I would comment,
Yeah,
as
it's-
Mr. King said, for each board.
Yeah.
This is for the Board of Selectmen, not each board.
Just
We're talking about
recog-
Section 2.
Mr. Chair, if I can just clarify, there's a lot of overlap between Section 2 that was not approved and Section 3 that was approved.
We're talking about Section 2, though.
Yeah, let's stick with what we're talking about
Yeah,
now.
so again,
When
it's
we get to
Section
Section
2.
3, you can make your comments.
Section 2 specifically addresses the Board of Selectmen. And I understand this idea, it doesn't say how long, it doesn't, but again, we get into that issue of guidelines. And I do think reasonable time, place, and manner, you could limit. You'd be amazed at how long 3 minutes of comment really is. And I'm at meetings where I have one town where the public comment, the comments under their regulations with respect to town meeting, and I wouldn't want to comment on, I know there was a comment made about town meeting, but they have a limitation in their charter, 15 minutes per speaker at town meeting. And
Still be there.
makes for a very long town meeting. But the comment was made that we already have a forum, which is town meeting. Again, I have to stress, town meeting is not subject to the open meeting law. It's a completely different forum. That's a legislative body. It does have an agenda, though. The agenda is the warrant. And so you don't have the opportunity to go off that agenda. In fact, there's no opportunity for public comment in the sense of to discuss items that are not on the agenda. You must stick to items that are within the scope of the article. You cannot go off tangent, and that's what the moderator regulates. To the extent that the moderator regulates personal attacks, items like that, they're simply not within the scope of an article. To attack or reference a particular individual, bylaws that are being proposed or funding that's being proposed at town meeting is not specific to an individual. So there really is there's no opportunity for personal attack or discussion of individuals at a town meeting that's not directed towards individuals. It's directed towards legislative action. It's unlike the general court that at times takes up matters of personal interest. Town meeting does not do that. I guess if it was a proclamation that was being issued through town meeting, then obviously we're talking about a personal issue. So I don't know. If we
Anything
wanna-
else on Article 2, Robert? Dennis?
Just one thing.
Section 2.
Section 2, I'm sorry. Yeah, Tim, go ahead.
So if residents want to continue to discuss and talk about public comment or getting it on agenda, regardless of board or committee or whatever, what you're saying is the discretion is at the chair, so go to the chair and discuss it with the chair. Is that what you're saying?
Well, ultimately, the chair would just, if somebody wants to, if a member of the public wants to ask that an item be put on the agenda, I think the chair has established a mechanism
Yeah, we
for
do.
that. Go to the chair and make that request, but the chair makes that decision.
Thank you.
Okay. So now, yeah, there's the further discussion. Section 3 of the proposed bylaw amendment was approved. That section reads, "The agenda for all open meetings shall be provided on the town's website for at least 5 business days in advance of the public meeting and containing all topics to be discussed, except that if the town's website has a loss of service or public meeting is called in an emergency, then the agenda shall be provided on the town's website as early as possible, provide an opportunity for public comments, provide a means of remote viewing and remote participation by the public." So that did result in several comments. Again, as we talked about with some of the zoning articles, there are cautions that were expressed within the Attorney General's approval letter. So the Attorney General made it clear that a bylaw can impose more stringent requirements. We see this with a lot of statutes. You cannot be less restrictive. So if a statute says you can only do this, you can't do less, but you might be able to do more. So in this case, a requirement for 5 days is essentially more permissive. It's more, it puts more of a burden on the town, but it's not more restrictive than what was allowed by the open meeting law. What the Attorney General did say is that the Attorney General would not undertake enforcement of that. So recognizing that and this pretty much goes through much of what is discussed in Section 3, the Attorney General enforces the open meeting law. The open meeting law has specific requirements. One of the requirements is 48 hours posting. Does not require 5 business days posting. So the Attorney General would take enforcement action if there was a complaint raised that a meeting was not posted within 48 hours as required, but the 5 days notice would not be subject to enforcement by the Attorney General. There is no enforcement mechanism for that 5 days. So it would be there, but it's what we would consider directory, not mandatory, in the sense that there is no penalty associated with it.
point?
Well, it encourages a longer period of notice, but it would not, failure to post with at least 5 business days notice would not invalidate the meeting, in my opinion.
Just one question on that. And the open meeting law requires it to be outside, not on the website. So is that correct?
Well, the open meeting law requires a posting on the bulletin board, and you may also use your website, but you can't exclusively use the website. This is requiring specifically a posting on the website. So yeah, but again, it's not specifically as provided in the open meeting law, but it's not inconsistent in the sense that it's a longer period rather than a shorter period. If the bylaw had said meetings must be posted 24 hours in advance, that would have been stricken, because that would be a violation of the specific requirements of the open meeting law. Opening it up longer, the Attorney General is not going to strike that, but is not going to enforce that. With respect to public comments, interestingly, the Attorney General specified that this cannot be applied to the Board of Selectmen because that would interfere with the board's executive functions, but approves it as to other boards, but goes on to say that it has to be applied consistently with that provision 20G of the open meeting law. No person shall address a meeting of the public body without permission of the chair, and all persons shall, at the request of the board of the chair, be silent. Specifically states the bylaw cannot be applied in a manner that would interfere with the discretion of a particular board's chairperson to conduct and control the meeting, including whether to allow public comment. So the issue there, and again, I think it's an interesting way the Attorney General did this, but essentially the Attorney General said, we're not going to strike it, but A, it's not going to be enforced by the Attorney General, and B, the Attorney General is not saying that it takes precedence over the specific language of the open meeting law. So the open meeting law provision still applies. A chair can say, no, we're not going to have public comment. It doesn't change what's already allowed under the open meeting law. I do have a concern with this provision, and it's one that I actually hope to at some point follow up with the Attorney General on, where it talks about provides a means for remote viewing and remote participation by the public. As we know, we're currently, even though we're outside of the pandemic, we're still under some pandemic special legislation and special relief. As you probably know, remote participation by a public body is allowed under the regulation, under the open meeting law and the regulations of the Attorney General, with certain restrictions. You can only have public participation if remote participation by board members if allowed by the chief executive body. So that the Board of Selectmen would have to enact a remote participation policy, which would then apply to all other boards. That's an executive function given specifically to the Board of Selectmen. However, during COVID times, with the signing of special legislation by the governor, which has been advanced through March of this year, there's an allowance, a relaxation of some of the requirements of the open meeting law, and an allowance for remote meetings. So the boards can meet entirely remote. They could meet in a hybrid fashion, and they can allow for the public to observe the meetings through Zoom and through streaming. There are a number of mechanisms that are specifically incorporated into the various special acts that have again been renewed through March. We don't know what's going to happen after March, so we don't know if remote participation in any fashion will continue in the broad manner that it's allowed under these special acts right now. If that legislation is not renewed, then we're back to the limitations of public participation as determined by a policy of the Board of Selectmen, and not the broad remote participation that's allowed now. So I don't know. I would just give caution that remote participation by the public must be consistent with the open meeting law and what's allowed under the current special acts that allowed for the relaxation of certain requirements of the open meeting law. So that would be a caution, and one that I look forward to a further discussion with the Attorney General on that issue.
Maybe you can get back to us when you have that
Yeah, I
discussion.
certainly can. I've raised it and have not. It's something that they're continuing to review. What they've told me is they've allowed that provision in other bylaws, but they also recognize the limitations. So it's still an area of consideration given where statute is. And again, it's talking about public participation as opposed to the board itself, and the current relaxation is primarily as to the functioning of boards. But how that intersects with public participation by remote means is obviously going to develop, especially after March, if that special legislation is not renewed. And there's ongoing rumor that might ultimately result in a permanent revision to the open meeting law, as opposed to what we're seeing almost year by year. You may recall we're on pins and needles every time the special legislation is reaching its endpoint, because the governor has taken to, the legislature and the governor have taken to extending that law almost at the 13th hour, not even the 11th or 12th. And so we're always concerned because meetings are scheduled with remote participation, and at the very end of the legislation, we're always concerned about will those meetings be consistent with statute. So that's really the discussion of Section 3. I do agree that it was not stricken, but there were significant cautions, again, specifically with respect to that 20G language in the open meeting law that allows the chair of any board to restrict public comment. I don't know if there.
No, any other questions from anybody before we go on?
Yeah, Mr. Chairman, it was pointed out that there's no enforcement to the Attorney General for this, but we have lots of bylaws, and I don't think the Attorney General enforces any of them. I mean, the bylaw is it's on the town to enforce its own bylaws, as far as I understand.
Just to that point, the Attorney General specifically enforces the open meeting law, and so that was the reference. The Attorney General would not enforce as a complaint under the open meeting law. And most of the bylaws we're talking about, these are enforcement of say zoning requirements or other requirements with respect to what is expected of the public. In terms of internal enforcement, the bylaws don't provide for a mechanism for that's you police yourselves.
Absolutely.
And then Section 4 was the requirement that all open meetings be video recorded, and that these recordings be made available 2 business days following the open meeting. And interestingly, what the Attorney General discusses is that, as you're aware, members of the public may record a meeting after notifying the chair. It's very, 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 in very limited circumstances can a chair limit the recording. So the limitation is that the chair can determine if it's a disruption to the meeting to allow cameras to be placed at a certain location. This really comes up in situations where there's a matter of significant interest where the press may attend, and you might have a bank of cameras, and it could be disruptive to the meeting. Or you might have an individual, and I've been at these meetings where an individual places the camera right in people's faces as they're speaking, can be very chilling on the discussion and very disruptive. So the open meeting law allows the chair to essentially reasonably restrict the placement of cameras. So obviously, a camera placed at a distance, not interfering with the meeting, really can't be objected to. But the chair can set limits if the camera placement or the recording device placement is disruptive. So the Attorney General references that the open meeting law allows citizens to make video or audio recording, again, not with respect to executive session, but with respect to open session. The open meeting law does not require that a public body video or audio record, and that because the open meeting law does not govern whether a public body records its meetings, cannot conclude that Section 4's video requirement conflicts with the open meeting law, and the town is again cautioned to apply the Section 4 in a manner that not to apply in a manner that interferes with the citizen's ability to record an open, not executive meeting pursuant to the open meeting law. So again, the Attorney General is saying, as long as you do this in a manner that doesn't interfere with an individual's rights, you couldn't say, as you announced at the beginning of the meeting is being recorded by the town, you couldn't then say, and therefore an individual would not be allowed to make their own recording. You couldn't preempt that. They're already allowed to make that recording. The issue here is the video requirement is specific to you, doesn't interfere with an individual's rights. The Attorney General goes on to talk about not being able to apply to recordings held in executive session. Executive sessions are very different, and in fact, I've been to executive sessions where members of boards have sought to record them, and we've recessed until that could be addressed. I generally am very limited in what I will address if an executive session is being recorded, because there's a lot of discussion on issues and items that there's a concern that if that recording should become public, it could compromise litigation strategy, collective bargaining strategy, or the rights of individuals under Exemption 1. So it's generally frowned upon to record executive sessions. It inhibits the intention of an executive session. So again, the Attorney General did not suggest that this recording requirement should extend to the executive sessions. We should be mindful of the time, only because I know you have.
No, I just.
No, I just
No,
want, I
this
know
is
you have.
important. I think you've been very helpful. I would like to say that, Robert's been recording for a while, and it's never been an issue.
No, and the,
Respectful and-
I know the issue that came out at the beginning is obviously that the request has to be, or the notification has to be given to the chair, and that should be done when the meeting is started, so that way it's on the record.
It hasn't been a problem.
Right, exactly. And then discussion about the requirement that the recordings be provided within 2 business days, and the issue of the public record law. The public record law relates to all records created or received by a town employee or official. So pretty much any record that's received in whatever form, be it photographic, documentation or recording, is deemed a public record. And I always caution public officials when they say, well, certain things are not a public record because they're exempt from the public records law. In fact, all these records are public records. They may be exempt from disclosure, from the mandatory disclosure requirement. So there may be exemptions that can be applied, such as executive session minutes and materials, certain privacy issues that are exempted if they pertain to medical or personnel records or matters of privacy, security records. There under Chapter 4, Section 7, Clause 26, there are a lengthy number of exemptions from the public records law, and I think what the Attorney General is doing is pointing out that these recordings may become public records law, and a determination of the disclosure is subject to the authority of the Supervisor of Public Records. The Attorney General doesn't oversee the public records law. That's through the Secretary of the Commonwealth and the Supervisor of Public Records. So that's really just a note. And it is important to note that recordings of public meetings themselves under the public records law are not subject to retention the way a written document is. So under the open meeting law, there's a requirement that minutes be maintained of meetings of public bodies. There's no requirement that it be recorded, and if the meeting is recorded, the recordings can be used to assist in creating minutes, but they don't have to be retained. And they could be recorded over, they could be discarded, unless there's been a public records request before they've been destroyed. So if the town records a meeting and someone makes a request for that recording and it still exists, it must be preserved and it must be provided, much like a request for draft minutes. The mere fact that minutes are a draft doesn't make them exempt from disclosure. They could be stamped draft, but if all you have are draft minutes and there's a request, the draft minutes are subject to disclosure. The requirement here essentially imposes a requirement that these records be retained and put on the website within I think it was on the website within, or made available to the public within 2 business days. So it puts an additional requirement that not only the meeting's recorded, but those recordings have to be made available. So you can't simply use the tape as a loop, so to speak, and record over them. You now would have to put those in some fashion, and so that there is that obligation created, and that was not found to be a violation of the open meeting law or inconsistent with the open meeting law. Yeah, we talked about it, and we talked about the limitations on a executive session. So that's pretty much the overview. Even the conclusion with respect to Article 21 again emphasizes Section 20G, the light switch. So if there's one takeaway, it's Section 20G and the authority of the chair of any board, not just the Board of Selectmen, although, again, the Section 2 is specific to the Board of Selectmen, Section 3 is not.
Okay. Any other questions?
Can I ask an off-topic one on public records? Well, I guess it's on topic,
It's on
but
topic.
Yeah.
if I'm sitting here taking notes, is that now a public record?
There's a specific exemption, it's called the notebook rule. If you're taking notes for your personal business, if you're not the recording secretary, so to speak, and you're taking notes for your personal information, that's subject to an exemption, the so-called notebook rule, which allows you to keep your own notes for your own specific purpose. Again, if those notes are referenced at a meeting, if you hold them up and read them out and make them a part of the record, then they would be subject to the record, but otherwise, they're your personal notes.
Tim, you all set?
I think I'm good.
Robert?
I just wanted to point out, Selectman Frick, that's in the training if you haven't had a chance to review it yet.
I did review it,
Okay.
but there was one place that said that it was and one place that said that it wasn't. In fact, it was in our training at MMA.
Yeah, the MMA was not, I don't endorse that particular training, but the training that the town had last spring that we were given the recording
I
to.
saw that as well, thank you.
Okay.
Yeah, it did have two different things in two different sections.
Yes.
I do have to speak favorably of Attorney Goldberg's presentation,
Yes,
of course.
Yes. Well, no,
I thought it was very good.
Thank you.
You have to understand, we have a certain group of people in town that think they're attorneys, and they're.
Well,
they give us
the
information.
law is not only for attorneys, and everyone's entitled to an interpretation.
Everybody's entitled to their opinion.
They are. These are complex issues, and not everything is intuitive. We spend a lot of. I've only been doing municipal law for a little over 30 years, and I've learned a few things as I've gone along. But I learn every day. And so, I think everybody learns from these discussions. We have the benefit that we spend every day doing this, and amongst the 40 attorneys, Attorney Goldberg and I spend more time than our spouses would like discussing open meeting law, public records, and town meeting, and because we live and breathe this stuff. I don't recommend that be your avocation to live and breathe this kind of stuff. It is a lot of it is very arcane, but it's very important to understand when you're sitting as a board. It's very important to understand.
No problem asking questions, and that's why
Always good
we
to
ask-
ask questions,
We
and
ask you to come in, and we depend on you for giving us the legal advice based on your experience and education, and at the end of the day, we have to kind of listen to what you have to say. Again,
Well,
answer
you
our
don't have
questions.
to. I just give advice.
That's right, that's right. But we appreciate the time that you've given us. You've answered all the questions.
I hope so.
And if you can get back to us regarding the other thing that's.
Yep, I like I said, I am going to follow up with the Attorney General, but,
Okay.
again, it was not stricken, so it is subject to publication of, and I know the town clerk is aware of this, that there's the publication requirement for all amendments to bylaws, and once that publication requirement is satisfied, then the amended bylaw becomes the bylaw.
No other questions? Then I think we're all set. We
Thank you, and then I
very
guess
much.
I will see you on Monday,
Monday.
okay?
Mr. Chairman, can we have a brief recess so I
Yes.
can talk with legal counsel?
All right, at this time, we'll take till what, 7 o'clock? That's when our next,
No,
Yeah.
I mean 5 minutes.
7:05 or something?
let's see, when's our next?
Your next one is 7 o'clock.
All right, so we're going to recess until 6:55,
Okay.
okay? We're in recess, thank I'd like, at being 7:58, I'd like to call the meeting back to order. Next thing we have on the agenda is our tax classification. We do have a note here from our assessor. It says, Principal Assessor Alex Zendix has asked the board to continue this tax classification public hearing as the town has not yet received the final certification of property values for the fiscal year 23 from the state. So I would like to reschedule this for the board's next meeting at December 20th, on December 20th, at 7 PM. So I am looking for a motion for that.
I make that motion.
Thank you. Do I have a second?
Second.
Tim seconded. I have a motion and a second. Any discussion? I'll call for the vote.
Yes.
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 And I vote yes. Let the record show 5 in the affirmative. It's been rescheduled for 7 PM on December 20th. Let's see, what's the next one we got on the agenda? All right. The next meeting hearing is at 7:15. I'm just looking to see if there's anything we can, do we want to do the Auburn sewer? We're going to go down to H, guys.
Will that take less than 15 minutes?
Yeah.
Okay. Okay.
Jared is here tonight. We're looking at the Auburn Sewer intermunicipal agreement. We've received a memo from our DPW Director, Jared Doval, which we so supposedly had a chance to review, but Jared is here. Jared, if you want to just come up and give us a brief explanation as to what you're looking for us to do here tonight, we would appreciate it.
Sure. Thank you, Mr. Chairman. So before you is an agenda item here to vote to extend the current Auburn-Oxford sewer intermunicipal agreement to the end of January. So this will be, I believe, the second extension that we're looking for of the current terms of the IMA so that we may continue to negotiate with Auburn specific terms of the current IMA. We're not looking for drastic changes in the current terms as they stand now. But because of the holiday schedule and previously some new personnel on both sides, I mean, this has been going on really since I've come on board as well. We've been looking at this IMA. We've just not been able to get to a point where we're ready to sign off on a more extended term. So this will give us a little bit of time. It'll also account for some rain dates per se with the holidays, where both towns can continue to negotiate the IMA and hopefully have a successor agreement in place by the end of January, which we anticipate we will. So that's what's before you here. The current extension expires December 13th, so this was the last opportunity to be able to get a vote in a regular board meeting to extend it.
So what are you looking for us to extend it to what?
January 31st.
Let's see. All right, thank you. Any questions for Jared while he's up here? All right, so I'm going to be looking for a motion to extend the agreement to January 31st, 2023.
I make
With
a
the town of
motion
Auburn.
to extend the current IMA to January 31st, 2023.
Second.
All right, we have a motion, we have a second. Any conversation, any comments? Okay, Amy?
Yes.
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 I'll vote yes. Let the record show 5 in the affirmative. Extension granted. I don't know if we got time to get one more in here. How about the approval of minutes for the November 12th, 2022 meeting? I'm looking for a motion to approve those minutes as written.
I make a motion to approve the minutes for November 12th, 2022 as written.
Second.
All right, I have a motion, I have a second. Any comments, conversation? Amy?
Yes.
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 I'll vote yes. Let the record show 5 in favor of approving the minutes. Let's see. All right, how about, I don't know if we got time for we only got
Wanna
a
do the
couple minutes. Yeah,
donation?
let's do the donation acceptance. We have, the fire department is asking the board to accept a $100 donation from Patricia and Richard LaFontaine to the Oxford Fire Department in accordance with MGL Chapter 44, Section 53A. I'm looking for a motion to accept this donation.
I make a motion to accept the donation in the amount of $100 to the fire department in accordance with MGL Chapter 44, Section 53A.
Second.
I have a motion and I have a second. Any discussion? Call for the vote.
Yes.
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 I vote yes. Let the record show donation accepted, and we thank Patricia and Richard LaFontaine for their donation.
Yep.
Which one?
Change in DBA
Keep
liquor
going.
license.
All right. We're looking for a change in the DBA liquor license. That would be in. The board is in receipt of an application for the change of DBA from Ashley Daler from Route 12 Variety. Ms. Daler, formerly Ashley Plas, was previously approved for a change of manager due to a marriage. The DBA is being changed to match the married name as well as the manager's name. So I'm looking for a motion to make this change.
I make a motion to approve this change.
I'll second it.
All right, I have a motion and I have a second. Any discussion? Call for the vote.
Yes.
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 I'll vote yes. Let the record show 5 in the affirmative. Change has been granted.
The next one's pretty straightforward, too.
What, the animal,
No,
the
annual
license?
class, yep.
Yep.
All
Just
right, well,
reading, yeah, go to that one and.
all right, let's go. Let's see if we got one more in here. The board is in receipt of complete renewal applications for the following licenses. I'm going to read the names in the record.
Class 1.
Class 1. AJEC Engineering Corp., P.O. Box 690, Oxford. CRW Court, DBA Wood CRW, 65 Leicester Street, North Oxford. LBI Motorsports, Inc., 3 Holland Drive, Oxford. MHQ, Inc., 19 Industrial Park, East, Oxford. Environmental Equipment Sales and Service, LLC, Pioneer Drive, North Oxford. And New England Choppers, 70 Old Webster Road, Oxford, Mass. If the board wishes to approve the above Class 1 license renewal, it may want to consider the following. I move that the board vote to approve the Class 1 licenses as read into the record for calendar year 2023, contingent on passing a successful fire inspection. Looking for a motion.
I make that motion.
I have a second?
Second.
Robert seconds it. Any,
I just want to make it known that New England Choppers happens to be my next door neighbor, and my vote is not influenced by that whatsoever.
thank you, Dennis. Anybody else? Call for the vote.
Yes.
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 I'll vote yes. Let the record show, motion approved, 5-0. I think it's being, oh, we got a few more minutes here. Yeah, let's go. We're on a roll here.
Going.
All right, we're gonna go to Class 2 license. The board is in receipt of complete renewal applications for the following Class 2 licenses. I'll read them as follows. Car Company, 184 Southbridge Road, North Oxford. Bonnet's Automotive, Inc., 456 Main Street, Oxford. Farah Auto Body, 204 Main Street, Oxford. Dudley Diesel Service, Inc., 28 Industrial Park, Oxford. G&P Enterprises, DBA Jay's Auto, 217 Main Street, Oxford. Chagru Auto Sales, P.O. Box 45, Oxford. NU Central Mass Auto Auction, LLC, 12 Industrial Park, Oxford. Auto Oxford Sales, Inc., 176 Southbridge Road, North Oxford. M&M Auto Body, 7 Industrial Park West, Oxford. Precaution Pencom, 1 Harlan Drive. Environmental Equipment Sales and Service, LLC, 9 Pioneer Drive, North Oxford. And Advanced Wheels of Tech, Inc., 6 Boulder Park Way, North Oxford. I move that the board vote to approve the Class 2 license as read into the record for calendar year 2023, contingent upon passing a successful fire inspection. I'm looking for a motion.
I make that motion.
I'll second that
All right,
motion.
we have a motion, we have a second. Any discussion, comments? Call for the vote.
Yes.
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 I'll vote yes. Let the record show 5 in the affirmative, none in the negative. Let's go on to Class 3. The board is in receipt of complete renewal applications for the following class, it says Class 2, I think it's Class 3, right? Licenses.
Yep, 3.
Farrell Auto Body, 204 Main Street, Oxford. Revolve Limited LLC, 11 Town Forest Road. I move that the board vote to approve the Class 3 license as read into the record for calendar year 2023, contingent upon passing a successful fire inspection.
I make that motion.
Second?
I have a motion and I have a second. Any discussion? Call for the vote.
Yes.
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 I'll vote yes, let the record show 5 in the affirmative. Motion passes. Well, Jen, we're not ready for your report yet, I guess. All right, so at this time, I'm going to hand the gavel over to Amy. She's going to be conducting the next hearing. I just want to make it clear that I am leaving because, using myself because I have, I'm using the services of the engineer that is representing the client tonight, and to avoid any apparent conflict of interest, I will recuse myself from this section. So Amy, the floor is yours. And just call me when you're ready.
Okay.
Just-
Do we have to wait? We have to wait till 7:15, correct?
Yes.
Yeah, we do have to wait till
I can
7:15.
do 5 minutes of my report if you'd like.
All right, why don't we do that? We'll have Jen do 5 minutes.
Talk about the
of a
parade.
report.
There are two special permit renewals for animals.
gonna have
you could
time?
do.
I don't know. I
Renewals.
have no idea.
Yeah, why don't we hold, because we don't know if we're going to need discussion.
Okay.
Why don't you start your report until 7:15, and then I'll leave at that point, and then we can.
All right, so, how could I not start out with giving acknowledgement about the tree lighting and holiday parade? Our tree lighting and holiday parade was not only fantastic, we had a record turnout for both of these events. And the parade of lights was just absolutely incredible and allowed both Mr. and Mrs. Claus to arrive in a very colorful way to the bandstand. We had 40 vehicles participate. This was only our second year. And families gathered around the entire parade route from North Station to Jocelyn Park. My elf hat really does go off to the fire department in particular, with Chief McDonald and Deputy Chief Belanger, who really pulled that together. Also, our DPW Operations Manager, Steve Esposito, along with Jared Duval, who's here tonight, really made the entire staff. They just participated in all kinds of ways, many of them up there, along with our Lieutenant Houdon. But they really got into the spirit. Our common looks beautiful because of the lights that they have strung up on all the trees. And of course, Lori Masoni with the beautiful holiday cheer buckets that are all over town look wonderful. And I gotta make sure we acknowledge our OCC Director, Shirley Lambert, who was just phenomenal with many of her jolly volunteers. They gave out more than 600 cups of cocoa and then ran out. Next year, we're gonna have to do better. I'm gonna have to look to some people to help us with that. And attendance was not only wonderful, there was the air of full of holiday cheer, especially from the DPW Grinch Mobile. And I would like to say that we're looking forward to doing it next year. I was told that we need a better announcing system because people all along the parade route couldn't really hear some of the comments that we were making and the acknowledgements. So I wanted to make the acknowledgements here tonight because people couldn't hear. This is a town-sponsored event, and it really is wholly organized and coordinated with staff, and then all of the volunteers that come out make it a wonderful event. Tax classification revaluation. You just got through actually moving the tax classification hearing, but I did want to give the board an update on the tax classification aspect. It's a revaluation year, and I'd like to thank our principal assessor, Alex Zenzik, along with our consultants, RRC and RRG, for all of their hard work. When you are in a revaluation year, you typically are looking at every single property, putting eyes on it, and looking to see what has happened over the previous years. There has been a slight delay in the processing because it is a reval year, and that's why we have just a little bit of a certification delay. I would have liked to have the tax classification here this evening. The preliminary outlook is looking very positive. I want you to know, as we're waiting for the Department of Revenue to certify our actual figures that we've put in, but it does look like we have positive new growth due to increased economic and residential development projects. That's terrific. If it gets certified, that will be very helpful in the overall positive impact that we'll have both to the rate once that is certified by the state and adopted by this board, which then allows us to send out the tax bills. So looking forward to that classification hearing with our new assessor, who has been working very, very tirelessly over the last 6 months. It's not easy to come in as a brand-new assessor and face a reval year. So great job to Alex. The next item is just to let you know that the Route 20 construction update. Mass DOT had their 20 pre-constructive conference on November 22nd, and the contractor DW White Construction, along with our DPW director and our Chief Sad and Lieutenant Marcelonis were in attendance. I have provided all of you a packet of the very extensive pre-construction slideshow that they had. Basically, it was announced that they may be looking at seeing on-site testing, survey work, and erosion control over the next few months, with land clearing starting as early as February. Where's Jared? It'll be interesting to see that, February 2023. Although the final designs have yet to be finalized, a few of the enhancements mentioned everything from roadway drainage, optimization. They talked about the environmental impacts. I know I had a number of slides here that aren't showing up, so I would appreciate if we can just move them along, Sammy. But there were a large number of discussions around the fact that they're going to put a roundabout at the intersection of Route 20 and Oxbow Road potentially, along with reconstruction of the French River Bridge. And I think all of those details are going to continue to get vetted out. This is a state project in the amount of about $90 million for about 3.2 miles. So, and most of it is in our community. So with that, I will just let the board know that aside from all of these finer details that will go to our professionals, I just want the public to be aware that we'll be commencing in early of next year, and that as we get to these kind of particulars, the public, when they have issues, are going to be directed to the state website for the Mass DOT on this project. They will hold hearings when they need input. That is when the public will get to actually weigh into it. And if there is something that requires the Board of Selectmen's actions, I'll bring it before the board. But having said that, I just wanted to let you know they're moving along.
Okay.
Thank you very much, and I'll
Thank you.
recess my report until the next agenda item hearing is concluded. Thank you.
Thank you. Okay, time being 7:15, we are ready to go through the continued public hearing of S&K Development LLC. I am going to read the public hearing notice. In accordance with the provisions of the Oxford zoning bylaw, Chapter 18, the Oxford Board of Selectmen held a public hearing on November 1st, 2022, regarding an application from S&K Development LLC, 710 Main Street, P.O. Box 744, North Oxford, Mass. 01537, for a special permit for earth removal on land located at 19 Oxbow Road, Oxford, Assessors Map 09, Parcel A-21. Please take notice that the Oxford Board of Selectmen will continue the public hearing concerning the special permit for earth removal to Tuesday, December 6, 2002 at 7:15 p.m. This hearing has been continued from the Selectmen's meeting of November 15, 2022, with the original hearing date of November 1st, 2022. The meeting will be held in the second floor conference room of the Town Hall, which is located at 325 Main Street, Oxford, Massachusetts. Do we want to reopen the public hearing, or,
I'll make a motion to reopen the public hearing.
well, we don't have to reopen the public hearing. We already closed the public hearing for evidentiary.
I'm assuming, well, speaking for myself, if I have other questions for the applicant, I want them to be able to answer those, and then, potentially, once you start allowing some comments, then,
So,
You can do that. I mean,
Yes.
you're part of the board. You can
Yeah.
ask the applicant. You don't need the public hearing open for that. Public hearing allows the public to add their time, and we already did that.
Right.
And so I personally don't see a reason to open a public hearing, but.
I agree with you. We can take, we just can't take new evidence.
Right.
I don't-
allowed to ask as a select, that's the reason for this deliberation at this point, is,
Yeah, my concern
us.
would be that if there's other questions, I want the applicant to have a chance to submit things. If there's other questions that come out of that, out of our discussion today, I don't necessarily want to close that door. I mean, I guess we could
We're
always
kind of here
reopen.
to
you're
vote
not
tonight.
closing the door, that's the point, is
Yeah.
that this is the time for selectmen deliberations with the applicant. You can ask the applicant, and there is nothing wrong. All we're doing is not opening the public comment to have the public come up and say more information that they weren't given the opportunity already before, and then we close the public hearing because we had nobody else. So I don't understand what your point is, you know?
No,
I
I'm
mean,
sorry. I didn't mean to make a big thing of it. I was just,
You're making a big thing of
I
it.
apologize.
So, Rod, do you have questions that you want to ask, right? Or
Yes,
we-
yeah, of
okay,
the
so
applicant, yeah,
Let's go through
so-
the questions that you have so that we can move forward to the vote part.
Yeah, so so my question, I had kind of reached out prior to the meeting with the DPW director to see if we could get this information, was about the original permit from back in 2003 or 2004, if we had that. And it doesn't look like it came in, and I mean, the board secretary, correct me if I'm wrong through you, Madam Chair.
Oh, you speak.
Oh, I apologize. Through Madam Chair, I don't believe we received any information about the original permit from 2003 or 2004, the
I
Selectmen's
don't have that in
Office.
the packet, no.
Okay. And the reason I ask about that is because at least in the last the filing from the representative for the applicant had kind of made some assertions about what the scope of the original project was. And I wanted to kind of, if we had that original permit, so we're not just kind of going off of what people say about it. I don't know how the other,
Madam Chair, I have a copy of the original, which what I think is the original permit, if it helps, but I don't know if it would give you enough time to look at it. It's lengthy, but
Yeah, I don't know that it matters what the original was. It wasn't this group.
could I explain, Madam Chair?
Yes, yeah.
So my feeling is, you know, I try to look at this from both sides, you know, and so if the applicant purchased this property with the understanding that basically this had already been approved before, then they would have a reasonable expectation that it would be approved with maybe with some certain conditions again. And so that's why I kind of have brought this up a couple times. I want to see the original one so I can look and say, okay, well, so when they purchased this property, they had a reasonable expectation that they would have had an opportunity to do the same reasonably similar project again. That was kind of my reasoning for wanting that.
Okay. Do you want to see the copy that he has?
Yeah, Madam Chair, if he could provide a copy for the board members to view.
I don't have copies for everyone, but I have a copy for you, Mr. King, if you'd like to look at it this evening.
I think, yeah, I would like to look at it, I mean, if the other board members wish to see it as well.
I don't see the relevance in this permit process that we're looking at right here. This is a whole different permit, it's whole different times. You know, it happened in 2003, you know, you're talking almost 10 years later. So what was granted there, to me, is not
Almost 20
as
years.
pertinent to this here particular applicant. So,
May I?
I mean,
Yes, you might.
I think what he's saying is the applicant had referenced that in this. So in saying that, you know, in the processes of being denied, that, you know, referencing the old one, if this was approved, why not this? So I think what he's saying is he'd like to see that old one as reference to understand why that one is approved and this one wasn't. You get what I'm saying? Just for
yeah, I do.
clarification.
And I don't understand why he didn't go and research this himself. He's had a month to do this. And, you know, we're looking at people that they're interested in getting going with some sort of either approval or denial. You've had over a month to look and go find it out yourself. Why are you bringing this up tonight and putting these people again in a position where we can't make a decision? So, yeah, sure, go ahead and tell me why. You can't walk into the town hall and find out the information that I can find out, she can find out, he can find out, any one of us on this board. I don't understand it. So, go ahead.
I apologize. I'm not trying to offend anybody. I'm honestly not. I had asked about this in the last meeting.
Then you go look it up, you know? I mean, you can ask all you want, but just asking on public TV and saying, oh, you know, I want to bring, go and look it up yourself, go find out the information. There's nobody stopping you. But now you're stopping these people from possibly having approval tonight because you're saying they reference a statement about how much cubic feet was going to be pulled out then versus now. You know, and to me, it's ludicrous anyway, because they're taking out less material than it was approved before. So, you know, if anything, they're better, in a better position than the last approval was. And that's my opinion on that. But again, you know, why you have to wait to the last moment, which you do an awful lot about a lot of things you bring up on public TV, I don't know, but
So we, as a board, should be making our decisions with information that's in the meeting. And so if I was to, on my own.
no,
get
that is
information-
incorrect. You as a board member can do your own individual review. You are not breaking any open meeting law or anything like that. You can go, just like if a resident comes to you with a concern, you can go and investigate that individually. You do not have to make everything open in public. You can present it in public, but you as a selectman have every right to go and research it. And that's the point I'm breaking out. Why didn't you, as a selectman, who is all for the people, go and research this before?
So if I can address that, Madam Chair. I had asked about it, and I was under the impression that we didn't have the record, because when I had asked about it, it wasn't provided, it wasn't in the record, and I must have misunderstood.
Wasn't provided how?
Could I please explain?
No, it wasn't provided how? You can go right down to the clerk's office, and I'm sure you can get a copy of that record.
Could I please?
I could be wrong.
So I think we're getting off
Yeah,
topic here.
I was just
would-
gonna say,
If I could help frame for the board through the chairwoman, that I think it's important for the public to understand that this board and a previous board because there were 3 new board members, this applicant has been before 2 boards. And in essence, this board has done its evidentiary portion of it. There was a willingness to come back by the applicant and a mutual decision with the board, because the board previously had made a decision. There's been new information that's provided to you. Our DPW director has provided you with a memorandum dated today about what has substantially changed, what hasn't. In here, he has talked about that there is additional topographic information that has been provided by the applicant. And also based on some of the other information that has come through attorney letter, as well as the applicant has provided to the board. I think it was the applicant's intention to provide additional information and maybe some scope of change. I don't know if you'd like to, even before the applicant speaks, have our DPW director provide you with an overview of that memo, because obviously, you have deliberated previously on this, and there are some things we might not remember that are relevant to the application at hand, that the applicant felt necessary to provide additional information. Is that kind of, I think that, so I think it would be helpful, what I'm trying to say is, have our DPW director come up, talk about his memorandum about what's substantially changed, what hasn't, and then, I think, if you can't make a decision, because tonight was about trying to come to a decision for the applicant, then you can ask additional questions based on the information that is at hand, because that's all we have right now, is what's at hand and you've been provided.
Madam Chair, may I make one comment just before DPW Director? And I just want to address an error in my letter about at the DOT commitment that is in this particular letter.
I figured.
Yeah, and and perhaps the DPW Director wants to address that too. At the time this letter was written, that was a possibility. It does not now exist. We have alternative evidence to provide for you for that, but I wasn't trying to mislead the board in any way. the balance was to try to get you this information so you'd have to read it before tonight's meeting. And at that time, this was a direct comment, but I understand from
We
Mr.
figured
Smith
that.
this morning that that isn't a possibility any longer. So I just didn't want you to think I was trying to mislead you. And
Things change.
Things change. Certainly do.
May I just make a comment just on kind of an offshoot of what Select Board Member King was questioning, in which I think direction he was kind of alluding to. The original permit that was issued based on the 1991 regs, which currently exist today, they're the same regulations. That application applied for just under 90,000 yards of removal, and we're proposing for 75,000. Granted, there's some materials already come off the property, so, and the information that we did not have was the original plans. I didn't have a hard copy of the plans. I had the original documents of the applications that were submitted to the town, but not the actual line work on the plan of how they graded the site. So I couldn't make a comment as to exactly how they previously proposed it. But from a volume perspective, we're in the ballpark with what was previously proposed, minus what's already come off the property.
Okay, thanks.
Madam Chair, if I may?
You may.
Thank you.
Thank you,
Jared
Jared.
Duval, DPW Director. So there was some changes between the original submission and the last submission and this latest submission here, which I had noted in this latest memorandum dated earlier today. So I'll kind of run through that quickly. Obviously, there was a lot of pages and enclosures here as well from previous memorandum that I drafted up as we had reviewed this project and had discussions with the applicant, regarding potential mitigation, in the form of roadway reconstruction. All those sorts of things are all framed in my previous memorandum, which is the very lengthy documents, but we did try to do an evaluation of potential trips to and from the site, to try to give the board an idea, the scale, and give, I think, a sense to the neighborhood of what they may be in for, right? So all that information still stands, basically, because the changes from the last submission are essentially more topographic information, existing conditions information was provided on the plan. I think at Selectman King's request, wanted to see that. I noted here, in the way of my review, looking at the performance standards that we sort of review these projects under, whether it's undermining, or erosion issues, it didn't change any of my earlier comments. It was just additional information, but the setbacks and everything was still upheld from the property lines, those buffers that that we seek in reviewing these projects. So no change in my comments there. The selectmen table was amended to read, the current board and membership of the board and positions. There was also one of the documents that I had reviewed and cited in this memorandum was the letter from Attorney Hennigan. Two of the changes I noted in this memorandum that I had taken from that or gleaned from that letter were the proposed means of egress from the site had changed from exiting the site and heading easterly on Oxbow Road to Route 20, that they are now proposing to take a right out of the site and head westerly down Oxbow Road towards Charlton, which would be some 1,700 feet or so of Oxbow Road remaining in Oxford before you get to Charlton. So I did note in here, I don't know if there's been any sort of conversation with, nor that if there even has to be, but maybe it's a common courtesy thing. Now this may have folks neighboring that may be subject to the same sort of concern. So I just noted that in here. Like to think that we would be notified of something of this magnitude just over our border, and how that may impact town infrastructure specifically. So I just highlighted that for the board's consideration. And the proposed permit duration was reduced, I think, from an original proposal of 5 years, which is the maximum, to a 2-year duration. But again, my subsequent comments in this memorandum talk about my earlier memorandum. A lot of the analysis and stuff still holds true, as the project scope hasn't changed substantially. I did note again some updated costs in the way of roadway reconstruction, just because when we started this process and looked at numbers, things have changed. The bidding market has changed. So those costs for any potential mitigation have changed accordingly and increased. You can see that here, a couple of scenarios here on page 2, depending on the limits of repaving, and that kind of hinged upon, at the time, their alternate access point that they were proposing, and also the tie-in point to DOT's project, because Madam Manager had alluded to before, it's a design-build project, so they're still not 100% design, but there is this notion of a a roundabout at Oxbow Road and Route 20. So that tie-in point on Oxbow Road could change as they finalize the design. And then I did want to speak to the letter. I did do my own, had my own correspondence with folks at Mass DOT, particularly the project manager for the Route 20 project, the project manager for DW White, just to see, so I could frame to the board the expectation of how quickly material may move, right? So, and Attorney Hennigan already spoke to that. It seems that at the onset, maybe there was a need. This project, from what I'm told from the lead engineers at DOT, is that it's a surplus job. So much of the material they need to actually haul off-site from the job, excuse me, with the exception of any select materials they may need for pipe backfill, of course. But, you know, there's not a need for that volume of material just at this time, is what I've been told. So, and then that's the gist of my memorandum, this latest memorandum.
Does anybody have any questions for Jared?
Madam Chair, just with respect to the need for removal of material, I'd just like to submit two documents. One is a letter from By the Weight Construction, Russell Jennings, to Mr. Jim Smith, agreeing to remove 75,000 cubic yards within a 2-year period of time. And also from a Larry McKissick's, who is Larry's Landscape, who also indicated to him an intent to help him remove the $75,000. So although the DOT interest in this did fall through, we do have these particular letters that I'd like to submit, which show that there is a need and the material can be removed within a 2-year period of time. I'll give one to Mr. Duval also.
Thank you.
I have copies too.
Oh, you do, okay, all right.
I think this would at least address that particular concern, if that was a concern, and I think it was. Oops. I didn't walk that way.
Yeah, sure,
Thank you.
I'll take that.
So you have a bidding war? Is that what I'm seeing here?
I hope so.
Selectman King, did you have a question you wanted to ask Mr. Duval?
No, so like I said earlier, my question was kind of limited to, because we, you know, it's not a criticism of anyone, but obviously, you know, we didn't receive this information until just, you know, less than an hour before the meeting, you know, just because of all the documents coming in. So I don't want to, you know, for that to be interpreted as like a criticism. I understand this is very complicated and we're all trying to get everything.
I hate to interrupt.
No, go ahead.
I'm going to have to recuse myself. One of the Russell Jennings is one of my clients.
Yeah, we have to,
You have a chairwoman, what would you like to do?
What does this mean? Who is Russell Jennings? Oh,
Madam Chair, if I would recommend, maybe you we have a 5-minute recess so you can confer with the manager.
yes. Can we take a 5-minute? It is now 7:35. We will come back at 7:40. We have a secret sign. We are back in session. Sorry for the delay, everybody. We are going.
Madam Chair, if I may, we've had something that was unforeseen this evening. We have a special type of permit that requires a supermajority of the board, and because we had another member recuse themselves, it means that that presents us with a different crossroads. I know our attorney for town council has spoken to both myself, yourself, and the applicant's attorney. There are a number of things that can be considered. I do know that there is a court order to make a decision by December 23rd. When I spoke with Attorney Lane, he's actually away from Christmas onward because he's getting married. And I don't think he really wants to talk about special permits. I'm sorry, Mr. Attorney Hennigan. However, we could continue this, because it should be to a date certain, which if our next meeting is the December 20th, if the applicant would agree to, December 20th at 7:15, by then you can have a conversation and maybe work with Attorney Lane about the court order, maybe move or petition the court to extend it a little bit more until Attorney Lane gets back, and then we can decide what to do with this, supermajority issue. And you may have some ideas about the presentment of that evidentiary letters and the like. Does that sound reasonable?
It's fine. It's fine with us. We agree with that, Madam Chair.
So I would entertain a motion to continue this hearing to December 20th at 7:15.
I'll make that motion.
Second.
And I'll call for the vote.
Yes.
Yes.
And I say yes.
Madam
Thank you
Chair,
very much.
On this matter, if the attorney or the representative for the applicant could forward that document for the original 2003, 2004. Thank you.
Yeah, do that tomorrow. Thank you very much.
Thank you.
Okay, now we need more. I know.
Never thought I'd have to do that.
Right? What's gonna come up?
It's gonna come up again.
Good eye.
Okay. Okay. There's Norman.
Did you text Norman?
Yeah, I
or
did.
what?
Did I hear him? I thought I heard him. He may have fallen asleep.
Is he not coming?
Went-
Tony, can you just, yeah, thanks.
It went to voicemail.
Yeah, he's,
Taking a nap. Getting a donut. It's a coffee, I think.
I should have made a pot of coffee.
I don't know. They're a little.
Oh, no Keurig here.
We can put a little table. We got outlets.
Oh, there we go.
Body fly. Yeah, I look this too. You did? Yeah.
Here you are. I don't ever want to see that thing again.
Break it, did you?
All right, what are we on, G?
I would go to, nope, the special permit for animal renewal, that would be I.
Aye.
All right.
Mr. Chairman, if,
Yes.
when we're ready to move on to the animal permits, I will have to recuse for those.
Okay, I think we're going to do that now, Robert, so thank you. All right, the next thing on the agenda is a special permit for Susan Provost at 36 Watt Street. The board decided at their last meeting to hold on this renewal so ACO Flynn could take a look at the complaint from Mrs. Provost's neighbor. So I guess what I'd like to do is start off the meeting. Kelly, if you could come up and give us an overview of what you found and give us some guidance here. Good evening.
Good evening. So on Thursday, June 2nd, 2022, I received a copy of a complaint that was sent to the Board of Health regarding property owned by Susan Provost at 34-36 Watch Street. I have included a copy of this complaint. There were several components to the complaint, but the ones that pertain to animal control would be the chicken shavings and the possible varmints in the old chicken coop. On Wednesday, June 15th, I went to 34-36 Watch Street and looked around the property. I saw a small amount of shavings placed around Ms. Provost's rose bushes and a small amount spread out toward the back of Ms. Provost's property. The compost barrel was on the ground, so I discussed using the compost bin with Ms. Provost, and she agreed to use it. The condition of the chickens in the pen looked good. I looked around the old chicken coop, and I did not see any evidence of varmints such as droppings or holes in the ground. On Tuesday, November 15th, 2022, I received a complaint from the Board of Selectmen's office regarding the renewal of Ms. Provost's special permit. I have enclosed a copy of the complaint from Mr. Brian Gagnon, 38 Watch Street. The photo taken from Mr. Gagnon shows a wheelbarrow with shavings in it. Appears to have been taken in the spring, and when I went to Ms. Provost's house, it only had a few leaves in it. I did see some kitty litter on the ground next to the fence line, and I asked Ms. Provost why she put it there. She said it was to stop the water runoff from coming into her yard. I advised her to throw the dirty kitty litter out in the trash. I have found out since then that it was not dirty kitty litter, it was just clean kitty litter, and that she believed that the water was coming from the cellar of the next-door neighbor's house, and she didn't want it to get into her garden, so she put the kitty litter there to kind of like absorb that. I looked around the property for evidence of rats, and I did not see any burrows around the old coop or the new coop. Ms. Provost told me that she had an issue with rats earlier this year, but she put out poison for them and hasn't seen any evidence of them lately. It should be noted that the whole neighborhood was complaining about rats when the apartment building across the street was emptied of its residents. The building was full of trash and was in bad condition. It has since been, well, it's in the process of being rehabilitated, but I do believe that the rat problem initiated from there. Mr. Gagnon has complained about bad odors from the chickens in the past, but I have never encountered an odor emanating from the chickens on any occasion that I have been to Ms. Provost's house. Ms. Provost does have some debris in her yard, but it does not affect the health and well-being of the chickens. During my inspection, I found no reason for the Board of Selectmen to revoke Ms. Provost's special permit.
Thank you. Any questions from the board before we ask Kelly to?
Sorry, Mr. Chair, if I may.
Go ahead, Tim.
I did see a letter by the neighbor. The only question I have was, is the original order, has been satisfied, correct? Like the moving of things?
Yes,
So
yes.
that's all set?
Yes, there is a little question of like the old chicken coop. So Ms. Provost, when she moved the chickens, she used a different shed that she had on her property, but it's probably, my guess is its estimation would be like between 50 and 75 feet away from where the old shed is. So that's no longer a chicken coop, but there is still a shed there. I don't believe that that has anything to do with the special permit. That may be another issue of zoning, if that shed should be removed.
Right. Okay. Well, I guess what I'm asking is that shed being moved was not on the original order. So it was the chickens to be moved, not necessarily the structure?
Right.
Got
The
it.
chicken coop.
Okay. That's all I've got.
I got the same question. I picked up the same thing that Tim did, and I'm looking at a memo from Rick Steer it?
Rika.
Oh, Rika, I'm sorry.
That's okay.
Sorry, Rika. But it says here that the old coop was never deconstructed as agreed upon and is likely home for vermins at this point. So I think, and I don't know, Tim, if you're reading it the same way,
So,
Was the original conditions that she take down and remove the original chicken coop? That's my question.
She did agree to take down the old shed.
Okay.
Verbally did agree to do that, but it wasn't in the special permit.
But she did agree to do it.
Oh, sorry. Yes, to my knowledge, I remember her saying that she would take that.
Well, they're going to come up and I'll ask them why that. I mean, that's the only issue that I have. That was my question to you. Dennis, Amy, any other questions?
I'm okay, I'm good, thank you.
All right. You can stay right there. At this time, anyone in the audience wants to come up and speak regarding this issue? If there's- Come on up. Just state your name for the record.
I'm Susan Provost. I'm the owner of the chickens in the coop. I guess the only issue I had with removing the old coop is Mr. Mason and Mr. Gagnon have a shed that is not even within their property lines. I've actually done the measurements in the algebra. I'm willing to remove the coop because it's less than 20 feet off the property line right now. It has my lawnmower in it, my snow blower, and other stuff. So it's not being used as a chicken coop. It's being used to store the lawn tools that used to be in the old,
Okay.
in the new coop that they're in. So I moved the tools from there, moved them to the other. Not to be a jerk about it, but I feel like they put up a fence and a shed without doing a survey.
I have to stop you there because that's not under the purview of the
So
Board of Selectmen. We got to stick strictly with the chickens.
If one of the things that needs to be done is that the old coop needs to be taken down, I will do that. That's not a
Okay,
problem.
that's fair. Anything else?
An interesting note is there's a 2-year history of harassment that's.
Again,
Okay.
we have to stop that. That is not under the purview.
Never mind.
You know, our hope for you guys is that you eventually get along, because it's not a very good living conditions for either one of you, but that's all we're going to say about it. We're going to, Tim, are you okay with the fact that they're willing to take down and remove that shed from the property?
I think if it's being used as storage, I don't.
Yeah, I would be, Mr. Chairman, I would be careful. I don't think within the chicken permit issue, particularly if it's not being used with chickens at the moment, that would be over exceeding the authority of the board and to determine and to make or to suggest it's a trade-off for that. I know that might have been when the chickens were there, that you needed a new coop. That's one thing, but now it's a new coop, so just.
It's actually in horrible condition. I'm taking it down
Okay.
anyways, but.
But the board can't tell you to do that, and you shouldn't, that shouldn't be part of the permit.
Well, my only thing is, she did commit to do it before, and she didn't, but I think it's a mute issue right now. If you're going to take it down, fine, and I won't put it in as a condition, as long as Tim's okay with it.
I'm in.
Thank you.
Can I ask one thing?
Yes, you
Can I
can.
take it down in the spring so I have time to put up?
We're not going to make it an issue.
Right,
That's
that's
up to
why I
you.
was trying to-
That's what she just said.
So it's not a condition, they're gonna vote
Right.
on it.
We're going to vote on it,
Okay.
and that'll be
All right.
it. But if you do what you think is in their best interest, to try to get along with your neighbors. Anything else? All right, I'm going to make a motion to close the public hearing.
There wasn't
wasn't a
a public hearing.
I'm not going to make a,
You gotta make
Gonna
a
call
Look
for the
for a
vote?
motion
make a
for,
motion
all
to
right,
approve the
I'm going to
special
make a
permit.
motion that we approve the special permit.
I make that motion.
I'll second that motion.
Any other conversation? Everybody all set? Okay, I'll call for the vote.
Yes.
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 I'll vote yes. 4 in the affirmative. Good luck.
Thank you. I'm starving. I'm going to go to dinner.
Enjoy yourself. All right,
I think you have one more,
Oh, sorry.
thank you, yeah.
I think you do have,
Oh.
yes.
Which one do we got here, Jen? Let's see, donations, we got the special permit.
You still have two special permits, that's it.
Yes, we have two, we
Where-
have
what
L, and then we have two things to do here. We have the,
Now,
L, and then.
She's helping the senior citizen. L. All right, next thing on the agenda. This is a special permit for animals. Karen Richardson and Elizabeth Dogue, 49 Fellow Hill Road, Glenn and Linda Kenyon, 58 Old Webster Road. They're looking to renew permits for, what are they for?
special permits for
Special
animals.
permits for animals.
Special permits for animals, so I'm looking for a motion to grant this special permit as requested.
I make a motion that we renew the special permit for animals for Karen Richardson and Elizabeth Doug at 49 Federal Hill Road and Glenn and Linda Kenyon at 58 Old Webster Road.
I will second that motion.
Any discussion? Call for the vote.
Yes.
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 I'll vote yes. Let the record show 4 in the affirmative, no negatives. Robert, I'm sorry, you ready to come back up? We missed you. All right, we took care of M. No, we're down to R, right?
Actually, you're down to Trinity Financial.
Yes.
Which one's that?
That's a J.
All right, next we have a presentation from Trinity Financial Company regarding the Orchard Hill redevelopment. So if you folks would be kind enough to come up and give us your presentation, we would much appreciate it.
Mr. Chairman, if I may, just as a, please have a seat. I wanted to just give the board a little background. Trinity Financial had approached the town, actually during the pandemic, about the desire to take our largest and mainly most extensive affordable housing development, and with the prospect of wanting to redevelop the property. And James Keefe, who's the principal of Trinity Financial, had come out to meet with staff leadership and a couple of the former chairman and the chairman of the planning board, just to talk very basically about the problem that Orchard Hill Estates is facing, give us a background about who he was and what he'd like to do to that development. The development is very important to the town in terms of its overall affordable housing inventory, and therefore, you know, it's important for us to think about the residents that currently live there and what we'd like to do to be able to listen to this proposal. And I think you'll find it very illuminating and encouraging, particularly because it's something that would be a vast improvement to what it has. And with that, I will leave Jim Keefe to do a wonderful, I think, presentation to the board as a preliminary introduction. So welcome.
Thank you,
Mr.
Manager
Keefe.
Callahan. Mr. Chair, members of the board, thank you very much for having us here tonight. This is really more a courtesy, just to make sure we don't get out ahead of you and other people in town in terms of what our plans are. I want to begin by introducing our team. We've got quite a few team members here. To my right is Jonathan Bramer. He is the project manager here. He's the vice president of development of Trinity. We also have David Wright, who's an associate at Icon Architects. They are the designers of, we're calling it the New Orchard, the New Orchard Hill Estates, but I promised Manager Callahan, you're going to come up with a whole new name. So we'll have fun trying to figure that one out. Also here with Andrew Arbar, who's the principal of Copley Wolf. They are our landscape architects. And also we have Chris Macon, who's the senior project manager for VHB. But the star of the show is Marquita West, who's the property manager here. Has been there for 5 years, and she truly is a star, and she's very kind to come out and join us tonight. My history with this property goes back a long time. It's almost 30 years when I got a phone call from Mass Housing telling me that they had a real problem with the property out in central Massachusetts, or what they described as central Massachusetts. They said it was the worst property in their portfolio. I don't know if anybody remembers the old Orchard Hill Estates, but there'd been a fire there. There was not enough water pressure coming to the site, so essentially it turned into being one of the most spectacular fires in the town's history. There was oil tanks, the lines of which that connect with the buildings that all failed. Many of them had failed, so there was an environmental situation going on. The buildings themselves were constructed in 1972, a very poor quality construction. A lot of corners were cut that ultimately we inherited. We had floors that were crumbling and bending. We had just an incredible number of problems with the property. And we got a call saying, would you be interested in acquiring this property?
Can't wait.
And this is the God's honest truth. I signed the purchase and sale agreement, sitting at the bar at Bakey's on Broad Street at about 9:30 at night, because in order to go forward with the transaction, we had to give evidence of ownership. I had never seen it. I had never seen the property. We were able to make a fairly significant investment in the property, new kitchens and baths. We reconfigured, it was really a bunch of boxes that we put, try to give some architectural flavor. We introduced some landscaping, but there really wasn't enough money to address the underlying fundamental capital problems that really ran all the way back to when the buildings were first constructed. We have owned and managed this property for over 20 years, and we've been really trying to keep it going, but every year it gets more and more difficult, to the point now where 17 or 18 of our units are now out of service. 18. Because it just doesn't make any sense to try to turn them over and make them occupiable again, because of all the complexities going on with the existing structure. I began a process, as Manager Callahan pointed out, that I started a process 2 years ago where I looked around to try to buy property in town where we could relocate this. That would have a number of positive objectives. One is we could just build it and then move people into that and not get into the complexity of relocation, just do it at once. Another one really tried to address one of the underlying issues that a lot of people there don't have good access to public transportation. And it would be great if we could get this community closer to a bus line so that they could access their jobs in Worcester, the commuter rail in Worcester. And, that's not everybody's need, but a number of people could really take advantage of that. The other thing that we, we had to do when we took it over in the early 90s, we had to build a sewage treatment plant. We'd never built anything like that, and the technology was relatively unsophisticated. But we had to do it because the current system was way out of compliance with DEP and at a higher elevation than Robinson Pond, which was never a great thing. So we did that, and we've been kind of holding our own there, but every year that goes by, we really keep our fingers crossed that we can keep it together. And but the big emphasis initially was to try to locate this on the sewer lines that currently service the town, somewhat limited. And but the idea would be we could connect to the municipal sewage system and get out of our own business of running a packaged treatment plant. And finally, one that's a very personal interest of mine is I'm not sure to what extent you're aware of the conditions there, but it's a long road from where people live down to Sutton Ave, where they connect the school bus. And I know firsthand, given all of us being parents, and many of us being parents with small children, walking to the bus stop, and it's 11 degrees outside, and the wind is blowing, is really a tough task. It's a tough task for the student, it's a tough task for the mother. And I am convinced that many a day of school was lost as a result of this long trek. So one of the things we're hoping to be able to come to an agreement with the town as part of this rather significant redevelopment is that we can talk about somehow figuring out a way to get school bus service up there, because a lot of kids are being underserved, and it's not fair. So that's my introduction. I'm going to give some closing remarks, but we've got lots to talk about, lots of cool pictures to show you. And with that, I'm going to turn it over to Jonathan Bramer, who's going to give you some sense of what we will be trying to do here and how we will need your help in order to be able to do that.
Thank you. Jonathan?
Thank you, Chair, Manager, board members. As Jim gave the history of Trinity coming into the development in the early 90s, many of that situation is echoed again today in 2022. As Jim noted, the buildings are really at a point that they just can't be renovated again and make any sense. So we're in the process of working with DHCD to try to do a redevelopment of the site. If we could go to the next slide, please, which has the existing. So,
I have to say, that looks pretty good.
That's from this angle, yes.
looks good.
That
from
is like the
here.
best picture I've seen in this place ever.
The roofs are in good shape.
Let's not talk about the foundations, right?
We got to do a better job. That looks too good.
Yes. So, it's an amazing site, 179 wooded acres. But the buildings were designed at a time that was much different. It was get in your car, avoid your neighbors, get in your house, go where you were going. it's not really designed for interaction. It's not designed to foster a sense of community. It really is a place where you go to sleep and then leave. And, you know, as currently designed, and its structural issues, it just really, you know, we just can't do what we need to do for our residents. Now, the interesting nuance of the site, as many of you likely already know, when it was built in the early 70s by the other developer, it was built by right in the subdivision zone. Shortly after its completion, the town of Oxford went through its rezoning, which then turned that site into an R1 zone, single-family residential. So the property's been a non-conforming use for most of its 50 years. And as such, to redevelop it as multifamily presents a number of challenges. So to that end, because we do think that the time is right, with the resources that are out there right now for housing, through ARPA, through the state bills, you know, we do need to move quickly, as well as the conditions really are not getting better. You know, the building continues to age, as Jim mentioned. The waste treatment plant is, you know, being maintained, but again, it needs to be new technology. So the most expeditious way to get this done, to redevelop, is working with DHCD and with the town on a 40B to get the plan approved. And the other part of what we're trying to do here is our main focus is maintaining the current 215 units, assigning the existing HUD contracts to the new ownership of entities of those 215 units. We are exploring the potential to add at some point additional units as well, which I'll talk about here in a moment. But really, we need to do the 215 units, and we need to do it in a way that helps keep the residents in place while we do the redevelopment, and also works within the available resources that are out there. We have we had submitted pre-apps to DHCD in this funding round, and we are working with them to hopefully we hope to be in a mini round later in the year. So to that end, we've divided this into two phases. Phase 1 is the replacement of the 215 units. So if we go to the next slide, please.
Oh, wow.
So as you can see, we're staying generally within the built environment of the site already. We went through a number of design iterations to try to figure out how we could keep people in place and also, redevelop these buildings. What's not shown, we don't have a graphic to show, but we did subsequently have to divide phase 1 into a phase 1A and a phase 1B. First, phase 1A is really that mid-rise you see in the middle, and townhomes to the right of it, and then off to the left. And what that allows us to do, and again, this is a work in progress, the hope is it will allow us to keep enough buildings in place during phase 1A that our residents don't have to move off-site, that we can house everyone still on-site while we demo the buildings that have to be demolished, and then build the phase 1A buildings, following right after, we hope, with the phase 1B buildings, once we've moved people into the new units.
I think it should be pointed out that you're seeing, this is a superimposed onto the existing Orchard Hill Estates. So if you look around the periphery, those are existing buildings, but this is just to illustrate how it's gonna be much more compact site than what's there now. And it also illustrates our ability to use some of the existing buildings to house people as we're phasing into the new development.
Yes, and so you also see that we maintain the existing main road. So we're really building ring roads around off of that main artery through the site. And the design team will talk more about how the common green is programmed, but we'll have mid-rise building here, and the rest are townhome buildings. So much more in line with building that sense of community where people are walking past, front stoops, and each person has they can go and do events in the common area. as well as the townhomes would have their own private backyards as well. In addition, in talking with the town and also, knowing that our own site's wait list is fairly substantial, we are, in our 40B application, going to be requesting the ability to add up to an additional 165 units, which would bring the site total to 380. Again, we don't know what that number will be at the end, but we want that ability. And what then happens, if we go to the next slide, please, you can see the phase 2 then fits very seamlessly, filling in the remainder of the site, and kind of closes it all in. That said, if we don't end up with those units, the phase 1 is designed to be a completely fully functioning, well-designed development on its own. So if we go to the next slide, please. Again, these are just to give you a sense. The main takeaway from this is that we are replacing one for one the existing New Orchard Hill units in our phase 1 through phase 1A and 1B. So it really is a replacement of the existing. And this site is, 215 of the town's 404 SHI units. So we do want to make sure we preserve that resource for our residents as well as for the town. And then, should we add up to that number, again, we'll work on refining the unit mix as we get further along, and the levels, but we are requesting with DHCD so that it's all able to accommodate it, that 380 in the first.
I think the spirit of this is that we want to incorporate all the one-bedroom units into one building. That we have a fairly sizable senior community there now, with the idea being that you come in one entrance, it's a secure front entrance, and then there's an elevator that can take you up to the top floors. That would be a nice convenience item for the seniors that are living there and the seniors that will live there. Putting them in that building gives us a lot more space to create the townhouse housing. And the emphasis, and this we didn't just make this up, this is very consistent with a number of projects that were done just like this. Everybody gets a front door, and with the exception of the mid-rise, everybody gets a front door, and everybody gets a play area or storage area in the back of their unit. Unlike now, there's kind of like no man's land. Nobody has any ownership over anything. It's hard to maintain, it's hard to police. But the idea be, it's a, you're able to park in front of your house like everybody else, and you bring your groceries in your front door. You're not going from a satellite parking lot, walking for however to get to your building and then go up 3 flights of stairs. So it's a significantly different approach than what was done in 1972, but we think it's going to be a significant enhancement to the quality of life in the neighborhood and make it that much more manageable.
And actually, that's a great segue. I will now turn over to David Wright and the design team to really talk about, what this program is going to actually look like for the residents and just what a tremendous transformation it will be in a sense of community for the folks who live there.
Madam Manager, members of the board, Mr. Chairman, David Wright with Icon Architecture. I'm also an associate with the firm, as it was mentioned by Jim Brommer. Can we actually go back one slide, please? So from this slide, you can see that we are actually creating, as Jonathan had said, a sense of community and a whole new neighborhood in a sense, where you have your own private neighborhood with a house. Granted, it's not a single-family house, but all the new roads, all new sidewalks. There's really no road sidewalks in the development as it exists right now. We plan on having all new road development with sidewalks, including the main access road. We're looking for a variance from MA, but you all know how steep that access road is. We do want to be able to get a sidewalk from the development down to Sutton Ave. Next 2 slides, please. So this is the concept landscape plan. I'm going to turn this over to Copley Wolf Design Group and explain the different amenities, especially the common green where there's a central gathering point in this community/neighborhood. Andrew.
Andrew Arbaugh, Landscape Architecture, Copley Wolf Design Group. I think just back to Jonathan's point again, the existing community is really not set up for community. It's set up for individual places. It doesn't create open spaces that are meant to gather. And that's the exact point of this plan right here. At the center, we have almost an acre of open space, sort of, because I can actually tall enough to reach this. So about an acre of open space right at the center of the community that serves as a community common. That's going to include both active and passive recreational space designed for the residents of the entire community. That can include things like community gardens, exercise equipment for active agers, and just a variety of different places that are currently not provided for the existing community. We're also going to be working with the grading in tandem with VHB, our civil engineer, to create places for on-site infiltration, and also to preserve as many of the existing trees that are on this right now that are part of what makes the site so beautiful in the moment that it is. In addition to the central common, we're also going to be providing a variety of other outdoor amenities and active spaces throughout the community, specifically within the 2 townhome clusters. So it's a space where we could have playgrounds for kids who are living in those townhouses come, that it's a little bit more enclosed so that you can come and feel safe and actually have some eyes on that space as well. Additionally, we'll be providing some court sports and bringing back some of the recreational activities that historically were on the site that have deteriorated over a period of time. So it's going to be transformative for the people who live in this community and provide just a level of recreational amenities that's unparalleled and just not there now.
You can go to the next slide. So you see the development of the second phase as well.
What's also from a landscape architecture standpoint so exciting is that so many of these come online during phase 1. So the amenities that make this a community are not something that the community who's there right now have to wait for. They really get that and get that transformation as part of the process early in the project.
Yeah, and an important part of that for us was we wanted to ensure that if phase 1 was if it became 215 units again in perpetuity, we really did provide everything to the residents that we sought out to provide. So as you can see, the way phase 2 comes online with the mid-rise and additional townhome units, you could add any mix of those buildings onto it to get to the correct unit count for that second phase, and they really do just blend seamlessly, but they're not essential to making the site work. And I would be remiss if I didn't point out that a big part of this too, down at the lower part of the plan, is completely redone, modern waste treatment plant that Mass DEP will be very pleased with. So we also have that, those engineers working on that as well. David?
Can we go back? Go to the next slide, please.
Sorry, one last thing I just want to point out on the site plan. I apologize,
fine,
but I think it's important to note.
We
because it has
practiced
been
this, you can see a lot. So far, so good.
You also saw
all
on the
regular.
site plan, if we could go back just one more time, please. We've done predominantly on-street,
Sorry.
I've been gabbling.
That's okay.
All right.
I'm not gonna use it.
We've been on-street parallel parking for the bulk of the parking requirements of the site, and we've tried to minimize large parking lots to the extent possible, because we do know that historically those have created challenges at the site for public safety and such, and so we really try to keep that to a minimum.
Can I just interrupt for 1 second? I'm looking at that picture. I don't see any impact on any neighborhoods, right? This whole area is surrounded by woods.
Oh, yeah.
It is.
And that's one of the complaints we get,
Yeah,
the negative impact that these types of development
yeah.
have on a neighborhood. You wake up one morning and there's a 4-story building in your backyard.
Sure.
So,
Yeah.
just want to point that out, you know, you're reusing what's there, so.
Yes.
Thank you for letting me interrupt.
Dave, I will turn it over to you for real this time.
Next slide, please. So obviously, this is a street view of how the site currently looks. If we go to the next slide, please. This gives you an idea of what it will look like. This is the main entry drive coming up. It's the main intersection where on phase 1 is a mid-rise. You're literally coming up the hill and making the curve. So I believe that this is the first building, one of the ones of phase one. I'm trying to get an idea where this perspective was taken. Next slide, please. That's our mid-rise. So there will be a drop-off area to come in. This works with, you can see the contour of the site as it's sloping down from left to right. We are actually developing the building to sit in the contour of the site. So it's 4 stories, but 1 story is a little bit lower. Half the building will be lower, 1 story lower as it works its way down this sloping site. We're trying to limit the cut of the soil as much as possible. Work with the existing grades of the site. Next slide, please. More existing. One more. An idea of what our townhouse buildings are going to look like as we step with the front entry stoops and the rear yards and landscaping. Our next one, please. So continue around some of the new streets, sidewalks, on-street sidewalk planting to really create that neighborhood in the community. Next, please. Now, I'm sure you'd rather probably see what our proposed elevations of these buildings actually look like. I'm sure. Next slide, please. So this is our mid-rise building. As you can see, it's working with the site. This is where this building will actually have, on the first floor, on the higher elevation, community space outside. You have the common area outside, the common green, community space on the first floor for the tenants, and it actually opens up onto that 3/4 acre common green. We can go to the next slide for townhomes. All cementitious siding. We're going to try to make this as high sustainability as possible. All new energy efficient systems, building systems. I believe we're going to go all electric. Yeah. It seems to be more efficient. And I believe that's our last slide of the presentation.
If I may, I think that when you talk about the mid-rise, you're hoping that those will all be basically 1-bedroom, so there is a need for affordable housing.
You don't want to put children in upper floors in elevated buildings.
Correct. Okay.
You don't want to mix children with old people,
Exactly, yep.
senior citizens.
Some of the townhouses, senior citizens, some of our townhouses will have, because we have to meet the accessibility requirements here in the state, right? We will have ground floor flats with walk-up duplexes above on the ends of the buildings. So this may not be one of these may not show the representation of it, but if you took this portion of the building, this whole area here is a ground floor flat. There would be 2 entrance doors that go up to a duplex above, and there's a 2-bedroom unit on one side and a 2-bedroom unit on the other.
Yeah, and it's important to note, so the unit counts that we're talking about and designing and programming for phase 1 are what we currently have. The 1-bed counts are the same. We've sort of...
You want to go back to that chart?
No, it's fine. I think we can talk about it in the abstract. So but here we've really aligned the units in a way that makes sense. Right now, they're just spread amongst buildings that don't really function and work well for folks. Here, we're getting the larger units into a townhome, so it feels like a home. It becomes, that family gets their own space, and they have a small backyard. But they're able to go right out and, interact with their neighbors easily and walk through the community. David's being modest in what Icon has put together here that we think is just tremendous in the way they've managed to design these that look like homes. The townhomes look like home. The mid-rise, its design is such that it's not just it's a big building, but it's not just a big, long, flat surface with a flat top. That 4th floor is, envisions, New England, old New England homes where it's a gable style in the roof line, but that's really actually a 4th floor of a mid-rise building that you might see in a square box. But they've done a great job of really making it look like something that we can be proud of once it's built.
So this is very early in the process, to say the least. This is what you call the schematic level. But this is very much consistent with many communities like this that we've done in the past, and they've been very successful, very transformative. So we're really excited about this. Another couple of aspects of this is that, one thing is, we've got 160 acres out there, and how many acres do we actually occupy here?
Less than 20.
So, there are parts of this I haven't ever gone near, not to mention, know anything about, but its proximity to Robinson Pond, I think, presents an open space opportunity for the town, because it's, it's there, you just can't see it. I mean, talk about it being isolated. And there has been some interest expressed to us that, as part of this, we might contemplate a future point to access the pond area and be able to really take advantage of its beauty, but it's hidden there in the woods. We can talk about how we can create public access to that in a way it can become a real open space amenity. The other thing about us is that we give preference to local contractors, we give preference to local residents, we will advertise, we will...
How about veterans?
Pardon me?
How about veterans?
Veterans, absolutely, that we have a very good track record of really trying to get as many people in the community, businesses, individuals, involved in benefiting from this. It's going to be a very significant number. I mean, we're talking well over $100 million, maybe as much as 150, and that doesn't include the second phase. So we ought to be able to earmark this money or try to make sure that we're benefiting the residents of Oxford and actually the residents here as well. So whatever job opportunities, whatever contracting opportunities that might be available, we're going to be looking for local contractors and try to get them involved. And again, we've got a pretty good track record doing that. A stronger community makes it a more viable, a better investment for us in the long term. So that's it. We're contemplating a friendly 40B. We have initiated the process with DACD, but DACD at some point is going to be sending a letter to Jonathan. Can you explain that?
So we'll be doing the application, which will then also be going to the Zoning Board of Appeals. They get a copy and a review period. I believe it's a 60-day review period of the materials and what we're doing, and then I don't know the process internally in the town, how the ZBA and yourselves coordinate or interact through that process, but
Well, I think I'm going to open up the questions to the board members. Any questions, comments? Tim, we'll start with you. Put you on the spot first.
Pretty easy.
Yeah, it is. Robert?
This is probably more a question through you, Mr. Chair, to the manager. I believe that this existing project already pays property taxes, correct?
Oh, yeah.
Oh, sure. So that's one of the things that I didn't want to steal the thunder of the
point.
presentation, because it's focused mainly on the residents and the quality of life and the hopes of, making improvements to an existing site for residents who are part of our community. And I think that's a wonderful thing to have a developer now want to come in and really make the community even more vibrant and reach its potential that it's never really been able to. But on your question, yes, they are like the second highest property taxpayer for this town. So in actually renovating and improving all of this, these will be new buildings. That's
Are you
first and
implying our
foremost.
taxes are going to go up?
You want my hammer?
Listen, we're in a revaluation year. We're in a revaluation. No, we are in a revaluation year, so, they might be coming in at a good time before all of those figures get recertified in another year. To the point of the importance of that, yes, it is always important to the town to have not only strong economic development, but excellent housing development, because it does contribute to us. Second thing that a lot of the board members may not be aware of is that our housing inventory is at 7.3% at the moment. The state has that 10% threshold that the town has to meet. If this development were to go someplace else, and we obviously, the staff in particular that understand how important this is to our community, didn't have a big sell, pitch to do, because the developer here, along with his staff, really want to make this happen here. So we were lucky about that. But if they were to leave, you know, we would be at the mercy of all kinds of potential 40B developments that are not friendly. And so to want to make this work, not only does it help us with the 7.3% that we already have, because we won't lose any of the existing ones, but the piece here and the willingness potentially to explore now a additional phasing of units in the future. Obviously, their main task is to get all of the residents that live there now and to reproduce the 215 units. But if the developer is willing to do, you know, future units for us, that helps us with our ability to put the state on notice that that is our work in progress towards 40B 10% threshold. So I think that's really important for this board and a future zoning board to really consider as we move forward. We may not have the same kind of voice, but I'll yield now. I just wanted to follow up with your question on that, Mr. King.
Anything else, Robert?
No, that was it. Thank you very much, Madam Town Manager.
Dennis?
What's your possible timeline? Are you talking years, you know? when-
We would like to get a funding award by the end of this year and be into construction by the middle of next year. That's
Wow.
very optimistic, but, you know, frankly, another thing that's going on is that the state has a lot of unallocated ARPA funds. And this could be a unique opportunity to help the state spend some of those funds, because they have to have them spent by, 2025. So they'll be looking for bigger projects. This is gonna, as I said, this is gonna be a very expensive project, to say the least. So the idea is to get this in front of them, get it funded, and once it's funded, we would expect to close within the next 12 months.
Right.
Yeah.
Thank you.
Believe me, you have no idea. You have no idea how badly we want to do this, and I think Jen and your.
Well, I kind of do, because I was in the initial meeting when you were talking about other properties and stuff like that, so.
Oh, that's right, you were there, yeah,
I
yeah,
was there.
yeah.
You know, it was very.
I didn't recognize you, we all had masks on, as I recall.
That's true, huh? That's right. But, it sounds great. Sounds great. Thank you. Thank
Thank
you,
you.
Mr. Chair.
So we can move in like
Amy?
2 years, I guess, to have my place ready.
Well, I'll tell you what, when you look and see how nice these units are, you'll scratch your head and say, this is pretty nice.
It
This is
almost looks
pretty
like a
nice.
college campus,
That was the idea.
really, with the.
That
with
was the idea.
uh,
That was the idea, and from a maintenance standpoint, and, you know, it makes more sense to organize it this way, because everybody has kind of ownership over their little plot. And if somebody isn't, you know, playing by the rules, it kind of, from a management standpoint, it's easy to manage that as opposed to if they're in this one big building and you don't know what unit they're in. So we're Marquita's really looking, Marquita's the most, she's the most enthusiastic about this
Well,
whole
she
project.
said so much, you know, I mean, I wish she'd
Believe me.
stop talking.
Maybe we should ask Ms. West, because I knew you were just last week going to inform her and show her the designs. Maybe you can come up and let us know what you think the residents up there would think for this, or what was your initial impression when you saw it? I know what mine was, but.
Well,
Hey, can
I
we go
I
back
think it's
2 slides,
amazing.
please?
The residents, I haven't been allowed to spill the beans yet, but the way they feel now, we've done a lot since I came aboard 5 years ago. We've done a lot to maintain what we have, but it's just like Jim was saying, it's just at its point where we only can do so much, and they're in need of something new. They see the new things that we do as a management team to, you know, bring their spirits up, different activities and everything else. But what we can't give them right now is a new place. I think that'll be the icing on the cake to give them home. Right now it's home, but it's like we understand things are falling apart. We understand there's only so much we could do to get it to, you know, where it needs to be. But something brand new, and just to see that we care. Before they didn't feel that, but they do feel that now that we're actually doing stuff to try to help their way of life. And, you know, I can't wait. I can't wait.
Make your life
We need
easier.
this like yesterday. Like it's going to be amazing. I think it's what the town needs. I think it's definitely what the residents need. The residents deserve. Some of the residents have been there since the beginning, so that's all they know. So, you know, to give them something new to say, hey, you know what, times are changing. We're gonna change with the times. We care. This is what we're gonna do. I think, you know, I can't wait. I can't wait.
Good.
I can't wait. Let's get it done.
Annie, you all
I
set?
would like you to start breaking ground tomorrow, so
Yeah.
we can figure that out.
Enthusiastic about it.
Anything else?
No, I'm good, thank you.
I just got a couple things. I think one of the things that we need to understand is that this, by doing this, it'll lessen the chances of us getting another developer to come in and stick one of these units, like we have a couple already in a neighborhood.
Yeah.
And I think that's a big thing. I did point out the fact that it doesn't really have a lot of impact, I don't think, on any neighborhoods. The other thing, Jen, is I know we've got some money now to do a housing plan. And my understanding is when you have a housing plan, and I don't know if Tony wants to get involved in this a little bit, that this would really tie in with a housing plan, because if we have a plan and we show that we're increasing this type of development, it helps us having a little bit of control if someone else came in with another project. Is that true, Tony? Is that something you can, I think that's an important aspect that the citizens need to know.
Well, this project's going to set a standard
Yeah.
that we haven't had before, and it will be married in the housing production plan. As we move forward, as other opportunities may arise, the phase 2 or whatnot, this is going to set the bar, not only in Oxford, but I also think in the region. So, thank you.
Okay, thank you.
Trendsetter.
I don't have anything else. Does anyone else have anything? Anybody in the audience?
So if I could leave you with an anecdote, I'm sorry, I didn't mean to, any other comments? I know people want to get home, but, you know, I take the work we do very personally, very passionate about it. And when my partner and I started Trinity 35 years ago, we were always focused on, would we live here? Would this be a place that we want to live? You know, I've always taken that kind of approach and thinking about how we can, and, you know, some of these families are struggling, some of them have limited incomes, they've got a lot of issues, and, you know, what can we do to kind of make their lives better, more secure? And I had a moment earlier this year. I bought a house, couldn't afford the vineyard, couldn't afford the Cape, so I bought a house in Hull, a summer house. It's like 45 minutes from where I live. But it's a great place, and among other things, having bought a house, I wanted to hire a surveyor to come in and just make sure that I'm not stepping on a neighbor's toes, you know, just trying to make sure there aren't any of those issues. And come to find out the surveyors, the surveying company's from North Oxford. And he rolls up in the truck, and I noticed North Oxford, and so I couldn't help but ask the kid. I said, you know, where are you from? And he said, Worcester. And I said, oh, no kidding. And he said, well, I was originally from Oxford. When I saw the Oxford, I said, so you don't live in Oxford? Well, he kind of then confessed, actually, I did live in Oxford. And I said, oh, really? No kidding. And he said, you know Oxford? I said, yeah, I own Orchard Hill Estates, and sometimes you don't know how people are going to react. But he said, I grew up there.
Wow.
He said that my mother had no place to go. Couldn't afford any other place. It was the only place we could live. And he grew up there. And here he is, you know, a surveyor. God knows what I'm going to pay for all of that. But it just reminds us once again that this kind of housing is really needed. And for some people, they need a break. They need an opportunity. And it just kills me that I should run into this kid who is probably making good money and doing pretty well. I know surveyors right now are really, really busy. But that just reminded me of what this is really all about. And so we'd be thrilled to do this. We look forward to working with your team. We've met with a number of, we met with some of the police folks last week. And just if anything comes up, that you have any thoughts, any ideas in terms of how we can make this better, you know, we're open to whatever suggestions. But we really want to do this in partnership with the town because I think it'll be an even better project. So.
If I may.
Dennis?
I'm very impressed. I was impressed the first time I met you. And what makes me happy about what you're doing now is that when you first met with us, you stated that you were on a site here that was almost undevelopable.
Yeah.
I can remember those words you saying, you know, so you were looking all around town. And some of the places you were looking at, so residents know, were gonna be very close to residential homes and things. And, so I, as a resident of this town and member of this board, just appreciate the hard work you've already put in, that you're taking this site that you said was undevelopable, and somehow you're gonna make it a developed, beautiful site, so.
Well, thank you.
My hat's off to you, and I have a lot of
Thank you.
respect.
We got a lot to do ahead of us, but
Yeah.
we're gonna see this to the end. If you guys stick with us, we're gonna stick with you,
Right.
and we're gonna see this get done.
Thank
And it'll be a credit to all of us.
Anybody else? Just as a side note, 30 years ago, I was the mailman up there. Just to let you know that.
Where-
Part-time, but I was, yeah.
That was obviously before we got there.
Yes, it
Yeah.
was before you got there, but there was a little post office up in the back, and
Really?
I'd be out there, certain people, I wouldn't even get the mail in, and they'd already have their hand to grab it. It was an interesting experience.
Yeah.
Anyway.
How's the mailman doing now?
They change a lot.
Yeah.
They change a lot.
Well, thank you very
Well,
much.
thank you.
I think
Appreciate
you
it.
can get a feeling from the board. If I'm out of turn here, guys, let me know that we're excited about this.
Great.
And anything the town can do to work with you on this, we would, you have our support.
Great. Thank you, Mr. Chair. Thank you,
Thank you,
members.
guys.
Really appreciate it.
Thank you.
Thank you.
Manager Callahan.
For waiting.
Have a good night.
Thanks for my hand.
Thank you very much. Mr. Chairman, would you like me to pick up where I left off for the town manager's report?
Sure. We've only been here, what, 4 hours now?
Yeah, well, you know, what are you gonna do?
Very good. Yes, Jen, if you would
All
be
right,
kind
sure.
enough to do that and finish up.
Yep. My next item is Cumberland Farms expansion. Recently, the Planning Board and Zoning Board of Appeals approved plans to rebuild the Cumberland Farms at 255 Main Street, spanning 4,000 square feet. The new building will feature the company's innovative design, modern equipment, and array of new food and beverage options for customers. As part of the project, Cumberland Farms will purchase the adjacent properties, and then that'll include, which already includes 2 buildings, that will accommodate the new building footprint for fuel pumps, parking, associated site amenities, including lighting and landscaping, which looks really quite nice, and beautification there. So in addition to the existing site driveways along Main Street, they'll be reconfigured to better consolidate site access for motorists and pedestrian safety. The project is anticipated to be completed next year. So both those boards have moved it forward. You know, this is, we have 3 of these in our town, but this one is going to apparently replace the one in the center here. Now, whether they'll ever redevelop the center, and we're not privy to that with the current configuration of leadership at Cumberland Farms, but it'll be something we'll enter into. You know, this was important for them to get approved, and so, and that site needed to be improved upon too. That, you know, this is right across from Hometown Liquors, basically. So, so that's a new thing that's gonna be coming online as part of our economic development. The next item is just to inform the board. I know that you vote on surplus items a lot, and our DPW director's here, and hats off getting our auction equipment for some of that surplus done in the past couple months, including 5 vehicles and 3 mowers, and as a result of the auction, we have a total amount of revenue coming back to the town of about a little over $34,000. So thank you for that, but I thought you might be interested in how that gets done. The next item is senior tax work-off program. I know Selectman Moriarty was at the senior center recently when Justin Ledoux did a presentation. I've asked him to head up the senior tax work-off program. We revamped it all last year, and we had a record number of people apply. We did a nice presentation, and I know our director for the senior center is here. And it was well-received, so much so that my office is already getting inundated by people that want to do this, which is great. It's a great testament that we're layering in our communications. So just to make the town seniors aware that the application period is open, they can either come by the town manager's office and get a printed copy or go online. under the manager's webpage and do an online application, or go to the senior director, who will help you even complete your application. This allows our seniors to get upwards of $1,500, which is subject to tax withholdings, but each year they're allowed to get up to $1,500. They have to be 60 years of age, and that'll come off their property taxes once they do their work hours, and we track them and we try to assign them to departments that they would like to work in. We will have 15 actual positions available, and if we receive the same amount of interest we had last year, we'll have a lottery, and then we'll get it done. So I just want to give people enough time before we head into January to notice this. So thank you, Madam Director, for allowing us to come and present. Next item is a small grant, but a very significant grant. One of the workings between myself and our superintendent and our former business manager there, who's now working on the town side, I'm pleased to say that we applied for a Maya risk, that Maya is our insurance carrier. We applied for a risk management grant, and we were receiving $7,700, a little over that, to replace the fan motors that are part of the high school's HVAC system, which actually wind up using a lot of energy. So now that we're going to have new variable frequency drives. We actually had put in for our green grant, our Green Communities grant, to replace some of these, not at the, I don't think it was at the high school, but one of the school buildings. So this is will help us significantly, again, cut down on energy consumption and extend the life of the motors and the equipment, so we don't have the big ticket item, hopefully, to have to repair. The next item is just to alert the board that recently we had staff safety and security on our mind, as always, and it's been paramount of importance to us. Unfortunately, we do have times where we have unsettling news, and we have to consider training employees about potential violence in the workplace. On November 17th, the town hall staff, all of them, participated in ALICE training provided by Sergeant Gurnett and Officer Mercier, and Chief Sad was here also from the Oxford PD. The material covered involved active shooter response, evacuation safety, and emergency communications. And I'd really like to say thank you to the police department for their support in enhancing employee and public safety across our municipal spaces. You know, I'm giving you just the broad slides because there's a lot of detail that was shared to us in that training that is not necessarily for consumption outside, because it would, compromise some of the areas that were important for the police to stress to employees on how to maximize their safety and protection should a really terrible event ever befall us. And if you look at the climate that is out there towards government and public employees, it's not always a pretty thing, and difficult. It can be very difficult for employees to have to consider. So thank you to the PD for helping us cover that. It's been on our minds, but because of COVID, training is different. And as Theodore Roosevelt said, and Sergeant Gurnett so eloquently put in one of his slides, in the moment of decision, the best thing you can do is the right thing. The next best thing is the wrong thing, and the worst thing you can do is do nothing. So we're trying to empower our employees to feel that they can do something even when they're struck with, a state of panic and fear. Next item is D. Green will make sure that I keep announcing this, that we are the Selectmen's office. So on your behalf, we are accepting photo entries for the 2022 annual town report that is done and commissioned through the Board of Selectmen. All the way, we're going to be accepting photos for our town reports, front page, back page, inside, up until December 15th. We are asking people to email their Selectmen entries to the Board of Selectmen, oxfordma.us. Include your name, address, telephone number, and the winner will have their photo featured on the front cover. So good luck to all who submit. And if we have a really hard decision, and sometimes I'll bring it before the board, and you guys can have the hard decision, we can decide what we really want to include, and is there another place we could do it? Yes, we can do that. Secret ballot, there you go. The next is just the reason why I'm doing some of these is we're in the holiday season, and the public might want to know, and the school definitely will want to know, because last year the school department bought a lot of tickets. I recently conferred with our superintendent that the Polar Park and the Woo Sox, we did a town takeover last year. And they're in the preliminary stages of lining up towns to do an Oxford takeover night at Polar Park for the Woo Sox. I have decided with the superintendent that one of the best days for that would be Thursday, June 22nd, next year. That will hopefully not conflict with our Little League Championship games, which are in July, and also, you can start buying your tickets in advance. What they do is they save a portion of the proceeds for all the tickets that we have purchased through residents in Oxford. Last year it went to the diabetes, the Barton Diabetes Camp, and this year it's going to go to the Oxford Community Center. So hopefully people might think about them for Christmas gifts, and in the end we could get the trophy. Last year it was Auburn. We were close, like second. But Auburn got the most attendance, so maybe we can establish a little competition with the school department and get some people, more people going. Next item is vaccination clinics. I am long trying to put out the messages that are sent to me through our Board of Health and our local regional public health group. The reason why I'm bringing this up is there are some upcoming vaccination clinics. They're not being held here, but they're being held both at the Webster Town Hall on December 10th, and also the Tri-Valley Elder Services in Dudley on December 14th. The reason why I'm mentioning this, it's for COVID vaccine clinics, for first doses, second doses, and boosters are available. And if you go, they'll also give you a $75 gift card. So if you think your health is important or that of a family member, you might also like the gift card and receipt for as long as their supplies last. But it's an initiative that's being done through the state and some of the local communities. The next item, because it's, again, season of giving, so the WRTA, which goes right up and down our Main Street, is offering free transit. They're asking 'tis the season for transit, and they're going to allow free ridership for the whole month, all the way up through December 31st. You don't need a pass. You know, you can actually go to one of our stops. The next slide I put on that we have actually 8 stops in town all along Main Street. Some people may not realize that, and that little graph is kind of hard to read, but that's where they're at. So this, you could take the bus, you know, as something to do for your holiday shopping, get out of town and shop in transit for free and not have to worry about that. It does, this bus line does go over to the Auburn Mall and eventually into Worcester as well. This is a
Mr. Chair, I apologize, Madam Chair. I was under the impression that the WRTA bus, that you could hail that. Is that not the case?
I think because we don't have, we have one bus stop that was new, thanks to our DPW director and our Main Street, Winter Streets program, no, Shared Streets, that's what it was, that you can do that, yes, because they need to know that you're looking for it. But you can also go to the designated stops, whether it's Holbrook, State Street, up here, you know, across from Sigourney, all the way up, you know, across from Walmart. It's, you know, these are all the stops, and most of the time, yes, people will put their hand up and that's how that goes. So that would be a good thing, unless in the future we have all these designated things, but that's even if you're not at a particular stop and you're close, hail it and run over, and I'm sure they'll pick you up. But this is part of a $2.5 million Mass DOT grant to reduce traffic emissions and the financial burden brought on by inflation and the lasting of the pandemic. So that's good. I had a last-minute entry for my report about Rocky Hill Pit, and I'm definitely putting it out there because I don't want it for people to say, why did we close it? Nobody knew about this. We'll put it on the electronic board, too. You know, if you haven't picked up your leaves and all your debris in your yard, you got to do it before December 11th, because on December 10th, which is a Saturday, so it closes at what, 2, roughly?
Yeah.
Yeah. So that will be the last day, December 10th, to bring your yard waste over to Rocky Hill for the seasonal closure. So if people can be mindful of that, that would be great. And the last part of my report is just to, again, 'tis the season because your next meeting isn't until the 20th, so I know I would get the wrath of our senior center director for not announcing a new fun activity called the Ugly Sweater Contest. Should any board member want to participate that day, you feel free to get your ugly sweater on. Go over December 20th at 12 noon, and that's a Tuesday, and it's be the day that they have their meals. There's also going to be a free movie on December 9th, later on this week, called Snow Day. That will be at 12:45 PM at the senior center. And once again, coming back, because it was so popular, so that's why I'm announcing it again this year, there is a free boxwood tree design class on December 8th at 12:30 with Herbert Berg, florist, who is very, very popular with all our seniors. And it winds up being a beautiful creation. People can't believe they can do this, and he gets us all excited that we can. The next is just the community center has 2 events coming up. One is gingerbread yoga. I just love that, so gingerbread yoga is going to be held December 8th and December 9th, so a Thursday and a Friday at 9 a.m., and then Fridays is at 1 p.m. And the program features gingerbread and holiday-themed yoga poses. So if you haven't done that, there you go. There's a cookie cutter I put on there that is a yoga pose. And then December 15th, there is a gift bow painting event, December 15th at 9 a.m. and December 16th at 3:30. Preschool kids and up can use their developing motor skills and improve their artistic abilities. And they can register with our community center. So lots going on, not only holiday parades, but our senior center and our community center are very busy. And that would conclude my report today.
Thank you, Madam Town Manager. Well, board, thanks for hanging in there tonight. I'm looking for a
I
motion to
make a
adjourn.
motion to adjourn.
Second.
Any discussion? All right, call for the vote.
Yes.
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 I vote yes, meeting adjourned. Thank you very much.